All persons having business before the Honorable Associate Judges, now presiding of the District Columbia Court of Appeals, draw near and give your attention. God save the United States and this honorable court. This honorable court's now in session. Please come to order.
Thank you. Good morning, everyone. We have 3 cases on the calendar this morning, and we'll take them in the order in which they appear. And I will call the first case, Anthony Waters versus United States. I will note before we begin that the amicus has been granted 10 minutes of oral argument in addition to the 15 minutes provided for the appellant. And appellee, the government, will therefore have 25 minutes to respond. And with that, Mr. Kaplan, I assume you'd like to go first?
Yes, Your Honor. Your Honor, if it please the court, my name is Matthew B. Kaplan. I represent appellant Anthony Waters, and I request 5 minutes of rebuttal time. Your Honor, as you know, the key issue in this case is whether 2 witness memos prepared by defense investigators were properly admitted for rebuttal use against Mr. Waters. The government says they were for 2 reasons. First, that the work product was waived because these memos were used at Mr. Waters' successful ineffective assistance of counsel proceeding, which resulted in the vacation of his first conviction. And second, the government says that even if that were not the case, it doesn't matter because these were Jenks material, would have had to been produced in any event. Let me start with the work product issue, and then I'll address the Jenks issue. Essentially, the work product issue is, did the disclosure of the work product, these memos, which were clearly work product, at the ineffective assistance of counsel proceeding, waive the privilege that protected these memos for all times and for all purposes? The key case on this issue, there's no case from this jurisdiction directly on point, but the key case on this issue is Bittaker versus Woodford, which is a 9th Circuit en banc case. That's the leading case on this issue. And Bittaker says that the waiver for the ineffectiveness proceeding only applies to that specific proceeding. The privilege.
Bittaker, I have a question about Bittaker, just kind of procedurally, because Bittaker the protective order was issued in conjunction with the habeas proceedings, if I'm getting this right. And so they addressed waiver sort of at the moment of disclosure, and the court entered a protective order. What's a little bit weird about this case is did anybody in 2015, when Judge Cannon ruled that there was a waiver as to the communications with Dorsey Jones and his investigators, did anybody ask for a protective order then? Or did anybody say, hey, whatever, we see you're saying this is waived, Judge Cannon, but please make sure that it can't be used in any future proceedings? Was a request like that made at the time?
No, Your Honor, and it would have been, as a practical matter, Mr. Waters was pro se and incarcerated. So I think as a practical matter, it would be very difficult to envision that happening. And one of the things I think that Bittaker says is that sort of the court is, in these type of situations, is sua sponte, has an independent obligation without being asked to issue such a protective order.
Do you think that somebody should have appointed counsel to Mr. Waters to advise him as to whether he should waive at that particular time his rights?
Well, again, he didn't waive.
Judge did it because, and said, well, I'm declaring a waiver based on the fact that he had filed a pro se 23-110 petition.
I think that might have been a better procedure, and I think that PDS can address this. I think PDS's suggestion is that there should be some kind of standard order that the Superior Court enters in situations like this, which is really what Bittaker seems to say. The trial court did eventually, or the 23-110 court did eventually appoint counsel, but that was after the disclosure had taken place, presumably because the court didn't want to appoint counsel until it had a sense that there was a potentially meritorious contention here. Bittaker's logic is simple. It says that notes that defendant, as in this case, who makes an ineffective assistance of counsel claim, almost always needs to waive the privilege protection of any materials related to his claim. If the claim is successful, as it was in this case, it means that the defendant was denied constitutional right to a fair trial and representation of counsel at his first trial. And, Bittaker makes the point that it would be entirely improper to allow the prosecution the windfall of using a defendant's attorney's confidential files against him at the second trial because of the happenstance that through no fault of his own, his constitutional rights were violated at the first trial. He didn't have effectively, he had no counsel at the first trial. And the remedy, Bittaker said, is to put as nearly as possible the defendant back into the position that he would have been if the violation of his constitutional rights had not occurred.
Does that mean that if in connection with the 23-110 motion, the defendant files, as we often require, witness affidavits, for example, in order to get a hearing, or calls the witnesses at the hearing and they testify, that the government, and then if the 23-110 motion is granted and there's a new trial, the government seeks to use the affidavits that the defendant provided or the testimony that the defendant presented at the 23-110 proceeding, for example, to impeach the witnesses if they testify for the defense. Does that mean that the government can't do that?
Well, of course, that's not this case, Your Honor, but I would think you'd have to look at whether the material was work product. If, the memo was something, I told a defense investigator this, that might well be work product. It was something that were more factual. I saw, I was there and I didn't see the defendant do this, and it doesn't relate to what was told to counsel for defendant. Then that might well be admissible. I think you'd have to look at case by case to see whether the information was work product, was protected by privilege.
So the proposition of privilege that you are arguing for is much narrower than the rationale that the Ninth Circuit offered.
Well, in the sense that the Ninth Circuit said that the individual should be put back into his position as nearly as possible. Again, that's not this case, but I think if someone enters something on the public record that's not privileged, I don't know that you could certainly make an argument using the Ninth Circuit, the Bittaker rationale, but that should not be admissible. But you certainly don't need to go that far for this case. The other point in Bittaker that I'd like to make is, that appears to be the universal rule. We cite a number of cases in which that rule which Bittaker has been followed. I mean, its logic is extremely compelling. It's totally unfair to the defendant to punish him for having had ineffective assistance of counsel at the first trial. And it's really, the government has cited no published case that is inconsistent with Bittaker. If there are any other questions about Bittaker, I'm happy to address them. I was going to turn briefly to the Jenks issue. Under Jenks, it's clear that only documents that meet the statutory definition of a statement need be produced. There are a number of cases, a lot of cases interpreting Jenks, but the key cases, I think the parties agree, are the Palermo case by the Supreme Court and the Coleman case by this court. Both are directly on point. Both these cases deal with situations in which the issue was whether specific interview memos of witnesses were Jenks material. And I want to just briefly quote, there's language which encapsulates the holding in Palermo and which was repeated verbatim in Coleman. And those cases both say interview memos that, quote, were prepared after the interview without the aid of complete notes and hence rest on the memory of the agent are not to be produced, unquote. And that is exactly the situation that
So I think we have a factual finding that this is something that I'm curious about. As I understand, the trial court said, well, looking at this, she must have had contemporaneous notes. And then she memorialized this memo based on notes she took at the time. That's how I understood the trial court's ruling. I take it you think that's clearly erroneous?
I don't think the trial court's ruling was based. I mean, the trial court did say that, and that is mistaken, and that's certainly part of the basis the trial court reached its ruling. But I think more fundamentally, I read what the trial court as saying is, just looking at the four corners of this memo, or this portion of this memo, that this qualifies as Jenks. I don't need to go to any external sources. Defense counsel repeatedly raised the issue that, this was not a contemporaneous statement. This was not a verbatim statement. And the trial court essentially said, that's enough. I'm not considering this issue any further. I've made my decision. So I don't think it was, I mean, it certainly was a mistake of fact to the extent that the trial court thought that there were contemporaneous notes.
To the extent there was an issue as to whether the statements were verbatim and contemporaneous, would the proper procedure have been for the judge to call, or excuse me, not the judge, for one of the parties to call the investigator to the stand and inquire of the investigator whether and to what extent the documents were verbatim and contemporaneous?
The trial court could have done that. And I think in a lot of other cases that might be appropriate. But I think looking in this case, I think looking at the memos, I mean, these memos are not clearly not contemporaneous verbatim statements.
Well, suppose the investigator said, well, it's certainly true that I waited a few hours before I wrote this up, and I wrote it up from memory. But at particular points in here, I have a very clear memory that I was quoting what that witness said to me. I mean, I'm an investigator for the defense. I'm trying to put down as much information for my superiors as I acquired that would be relevant to them, and as accurately as I can. And when I said that this witness said X, I had a clear memory of what she said. There wasn't that much time. It was important to me, and I wrote it down as she said it. I didn't try to change it. Would that have made a difference in terms of the question of whether this was a verbatim and contemporaneous, or whether parts of the investigative memoranda were verbatim and contemporaneous?
Well, a couple of points. First of all, obviously that's different from the fact pattern here. But one of the focuses of the Supreme Court is in the Palermo case is you need the complete statement. I don't think it would be, if they're just excerpts, the complete statement, at least to the extent that is relevant to the issues in dispute. And so if the investigator said, I remember specific statements and some of those I wrote down, no, I don't think that would be enough.
Suppose there was a sentence in the memorandum with quotation marks around it. The memorandum said, she said X. And would that be, would that survive? Would that pass the hurdle of Jenks?
If it was a near verbatim recordation of a complete statement, for example, in one of the government's case in Robinson, you've got a very brief statement that, so-and-so, I recognize this picture, something like that. And in a situation like that, even if it was a little bit after the time that the notes were, or the statement was written down, it's, that's a complete statement. And, if the person testified that those were the actual words, yes, I think that might qualify as Jenks. But it would be certainly a much more difficult case if the investigator said, I remember everything the words that the individual said, and I copied it down verbatim. I think it's important that the investigator have to testify. It's not just I didn't get the gist of it. I didn't get the important points. I copied down word for word what the individual told me. And I think sort of the thrust of the statute, which were their contemporaneous requirement, is that, that testimony wouldn't be very credible. And we have the language I just quoted from the Palermo case, which says, if notes are not taken during the meeting, during the interview, it doesn't qualify as Jenks. And I think that would end the matter. But again, in this case, we do not have no one's reporting.
It's sort of an interesting question about discrete statements. We talk about the Krupp memo as if it's a statement instead of looking at particular sentences that might be individualized statements. And I don't know if you put any emphasis on this, but it strikes me that where the impeachment is by omission, you would seem to want, not just if there were sprinkled throughout this discrete statements that were taken verbatim and recorded, she etched them in her memory and then wrote them down later. It's still tough to see how the entire thing would be considered Jenks and be appropriate for impeachment by omission, given that the whole, conceit of impeachment by omission is, this is I've captured it all, and she didn't say anything about it. And I guess you don't put any weight on this being an impeachment by omission in that respect, though, do you?
Well, I think if I understand you, Your Honor, I think that's a very valid point. It's especially important in this case that you have a complete verbatim record of everything she said, because the allegation here is that she said a lot of stuff, but she didn't say something that was important. And in Palermo, the Supreme Court talks about, I believe it's Palermo, that you've got to be very careful about selective quotation. That's one of the most pernicious manners of misquotation. You selective quotation just to select particular portions of a statement. So I agree with the point that I think you're making. Maybe we should have emphasized that more. But I think there was the key point here is that she didn't say something which she might have been expected to say, but it's not a verbatim transcript. We don't know exactly what it is that she said.
Can I ask you? I know your time is up. But I want to give you a chance to talk about harm, at least for a moment, not to derail the Jenks conversation if my colleagues have more questions about that. You and the government disagree about whether or not this is Chapman or Kodiakos. It's kind of an interesting question, I think. Assuming we thought there was error on the Jenks analysis. And let's assume that we thought there was error on privilege too. In one sense, it's sort of a statutory error under Jenks, really a rule error under Rule 26.2 that would ordinarily evaluate under a Kodiakos standard of harm. In another sense, I guess it gets to things that might otherwise be treated as privileged, and you might think of it as a constitutional type of harm. Do you want to give a defense of your view of why you think it's constitutional?
Well, I think everyone is entitled to be represented by counsel, including at the second trial, and everyone in the trial entitled to due process to a fair trial. And it's a fundamentally, I think it rises to a constitutional violation to say, hey, the government, it's not reciprocal. The government has sort of the happenstance of what happened at the first trial. The government can look through the defendant's files and use those files for whatever purposes it wants at the second trial. Even if they're not introduced, they can use them for, to assist strategy at the second trial. And I think that's monumental. I think that's so inconsistent with concepts of due process that it rises to a constitutional violation. But in this particular case, I'm not sure the standard of, the standard of harmless error makes that much difference. I mean, what you have here is you've got two alibi witnesses, one who says this guy was with me at the time of the murder. And you've got
contradicting Mr. Waters' own statements, though.
Well, as Judge Cannon said in adjudicating 23-110 motion, everybody, prosecution and defense, witnesses on both sides repeatedly lie. They didn't tell the truth during the course of this investigation. So,
It's a particularly funny kind of lie for a defendant who's been picked up on a murder charge to give his alibi, and instead give a different alibi, a nearby alibi. And I was in Miss Mills' apartment rather than I was with Kiki Williams, and I didn't hear the shots or anything like that. That is that's a strange lie to tell. It's not like I didn't see anything. I don't want to be involved, which is a kind of more routine type of lie. This is you've got, and I'm not saying it couldn't happen, but in terms of harm, it is awfully hard to think that a jury would credit Miss Williams' statement when it contradicts Mr. Waters' own statement about where he was at the time of the shooting. No, you don't think so?
Well, I think there's strange things were said on all sides, Your Honor. One of the government's two key witnesses at one point told the police that the killer had a ponytail. Not that she didn't know who it was. This guy had a ponytail, and she said, "Well, that was a lie." I just said that. Why she said that, I don't know. One of the other government's witnesses, literally, the other principal witness, literally had severe mental health issues, and literally had reported seeing little green men. So people said things that were surprising on both sides of this case. And I think it's sort of fundamental to our system that Mr. Waters had the right to have a jury sort out who should be believed.
Counsel, I know you wanted to save a few minutes for rebuttal, and we'll give you that opportunity. Let us hear from counsel for amicus.
Thank you.
The court, Shilpa Satoskar, on behalf of PDS as amicus in support of appellant. And I'd like to, if the court would allow it, I'd like to save 3 of my 10 minutes for rebuttal. And I'd like to address both of the issues that we raised in our brief. So starting with the Jenks issue, the PDS investigators' memos here were not Jenks statements of the witnesses. They were not the witnesses' own words, which is what the Jenks Act and Rule 26.2 are intended to capture. They were not substantially verbatim, and they were not contemporaneously recorded. And appellant's counsel has already read the very clear language from Palermo and Coleman saying that summaries that are prepared after the interview without the aid of complete notes and rest only on the memory of the agent are not to be produced. And I'd like to focus the court on the subsections in Rule 26.2 and in the Jenks Act. And I think it's very helpful to look at the 3 subsections. They're intended to be 3 different ways of covering only the witness's own words, right? So the first one is a written statement made and signed by the witness or adopted by the witness. The third one is the witness's grand jury testimony. And the second one, which is at issue here, is intended to be as close to those as possible, right? So it has to be under Rule 26, a substantially verbatim, contemporaneously recorded recital of a witness's oral statement. And in the Jenks Act, it also includes language such as, stenographic, mechanical, or other recording. All of these make it clear that, the subsection 2 is a very tight requirement that is going to cover just a statement that can be considered the witness's own words in a similar way as a grand jury statement. So here, moving on to the memos at issue here, I think the clearest requirement that was not met here was the contemporaneously recorded requirement. The witnesses testified that they did not take notes during the interviews. They prepared the memos only from their memory or their recollection between 1 to 7 hours after.
Just to pause there, remind me, tell me if I'm wrong about this. The trial judge, when he ruled that this was Jenks, did not have that testimony, right?
That's right.
He ruled based on the statement alone. And when he did that, did anybody say, Judge, you've really got to hear from the witnesses. They're going to tell you this was not contemporaneously recorded. There were no notes or anything like that.
Defense counsel did say these were not contemporaneous. This was not a statement of Ms. Williams in reference to the Crute memo. And I don't recall, I'm not sure whether he specifically said you need to hear from the investigators, but he did object that these were not contemporaneous or substantially verbatim, and they were not the words of the witnesses. But you're correct, Your Honor, that the judge ruled without doing the inquiry that even the government acknowledges the judge has an affirmative duty to do, to figure out whether the statements fall under these two requirements of Jenks. And it appears that what the judge's ruling was based on a factual finding that was not at all supported by the record. In fact, later, as you say, it turns out when the investigators testified that it was contradicted by the record. The judge said numerous times that he believed that these memos were a duplicate of notes that were taken during the interview, and that turned out to just not be true. So that was an abuse of discretion. That ruling was not based on a firm factual foundation. And if you look at the government has not cited a single case in which notes are not taken during the interview, or the memo is not written while the interview is happening, and the statement.
Counsel, to that and your point about the 1 to 7 hours later, what do you make of the language immediately following the language in Palermo about resting on the agent's memory? In expounding this standard, we do not wish to create the impression of a delusive exactness.
Well, I think that there's two things. One, Palermo very clearly says that if the memo is not based on complete notes and it rests only on the memory of the agent, that it is not to be produced. And the reasoning is because Congress wanted only the witness's own words. If something is filtered through the memory of the interviewer, it's much less likely to be the witness's own words. And I think and in Palermo, the court didn't mention at all how many hours or how long after the conference the IRS agent wrote the memo up. It simply said that it was prepared after the interview, and that's what was the critical fact. And if you look at this court's case law too, it's very clear that the court has always considered notes that are taken during an interview as contemporaneously recorded, but not if they're taken after. So these are all cited in our briefs, but I just want to quickly explain why that is. So of course, in Palermo and Coleman, the notes were taken, there were no notes taken during, and those were not Jenks statements. In March, Sims and Hernandez and Matthews, all from this court, they're cited in our brief, and also I believe in appellant's brief, there was evidence that the notes were taken during the interview. And in March and Simmons, they were held to be contemporaneously recorded, but not substantially verbatim. And in Hernandez and Matthew, the notes were taken during, and the court remanded for a determination about whether they were substantially verbatim. So there was no question that they were contemporaneously recorded. And I think the most helpful case to look at this distinction is this court's case in Lazo, because there were 3 interviews, okay? And in 2 of the interviews, there was a factual question about whether notes were taken during the interview. And the court remanded and said, on remand, trial court, you should determine whether notes were taken during the interview and also determine whether and if so, whether they were substantially verbatim. The 3rd interview, the prosecutor was the interviewer and told the court that she did not take notes during the interview. And that was the end of the Jenks inquiry. They were not contemporaneously recorded, and this court affirmed the holding as to that interview. So I think it's very clear that there is a line for contemporaneously recorded, that, the line is at the end of the interview. If they're taken during the interview, they're contemporaneously recorded. If they're taken after, they're not. And moving on to substantially verbatim, the memos on their face here, there's no support for the judge's ruling that they were substantially verbatim. I mean, they're clearly summaries of the relevant information that these investigators learned from witnesses. The Crute memo is a condensation of a nearly half-hour interview into just fewer than 30 lines. They obviously condensed what they learned. They put in what they thought would be helpful to the attorney that they were working for. They're well organized, they're succinct, They're incomplete sentences. They don't have any tangential information that would come out during a normal conversation with somebody. They have no quotations, no witness slang, and they're stripped of normal conversational context, as the court said in Martinez. In the Crute memo, there's also misspellings, factual misunderstandings. So it's very clear that these memos are summaries, and they're exactly what the court said in Palermo, that are not producible under Jenks. They're summaries of an oral statement, which were prepared after the interview without the aid of complete notes, and hence rest on the memory of the agent. And so they should not have been produced as Jenks.
May I ask you a question, which
Yeah.
is, I suppose, a practical question? Suppose we posit that indeed these memos were not Jenks and not producible under Rule 26.2. Suppose we also posit, however, that they were not privileged, or that the privilege was waived, so that the government can use what it learned from getting those memos in the 23-110 hearing. Would you agree that regardless of whether the memos are Jenks, or even assuming they're not Jenks, the government could still undertake to try to impeach Ms. Williams and Mr. Moore with their prior inconsistent statements, essentially in the normal or usual way it is done, by saying to them when they are on the stand, asking them whether they said X to the investigator when the investigator met with them, and if necessary, calling the investigator to complete the impeachment by asking the investigator on the stand, well, what did this witness tell you? And if necessary, and could even use the documents themselves, since the government had them, as to a fresh recollection, or I suppose to impeach the investigator if necessary. Am I right about all that? It sort of makes me wonder how significant the Jenks Act ruling is in and of itself.
I'm not sure I understand the privilege part of the question. Is Your Honor saying that
Well, if the privilege was not waived, and if we agree with Bittaker, and then if we adopt that, then the government can't do any of what I've said, because they'd be using. So that's why
right.
I was taking that of the equation for purposes of my question.
I mean, if the information were not privileged, which I think is not the case here, obviously.
Well, I understand that point.
Then I'm not sure how the government would have these memos, because I'm not sure how they would have gotten the memos. That there isn't, I mean, they don't have a reverse Brady obligation. We don't have a reverse Brady obligation, to turn over impeaching material or anything like that. So I don't think that they would have even had the materials to use them.
No, suppose the witness had previously been interviewed by the government and told them, I spoke to the investigator. Or suppose the government had just gotten the memos, as had seen the memos as part of a litigation over whether they were Jenks material. I mean, I guess it's possible they could have seen them.
Yeah, I mean, maybe there's some world in which they had a valid reason to have them. I don't know how that would have happened, but if you're saying that they were not at all privileged, then maybe they could have used them, but that's just not this case. I mean, in this case, if I could move
we have
on.
to deal, it shows, I think, the importance of dealing with the privilege issue in this case.
Yeah. And so I'm happy to move on to that issue. As we said in our brief, we believe that the court should follow the Bittaker framework that's also been followed by many other courts around the country, and not allow, and make clear that an implied waiver of privilege for purposes of an ineffectiveness claim is very narrow in scope, and it does not allow for either the disclosure or the use of those privileged materials for any other purpose in any other proceeding, including a retrial. And there are two things that we believe the court should require to be done in the trial court to make sure that this mechanism is enforced and the privilege is protected adequately. One is what Bittaker required and what Nicholson also required, the Fourth Circuit case, then that is to require the trial court to enter a protective order delineating the narrow scope of the privilege before the documents are turned over. And, you can read the protective order that's in Bidiger, but the three things that PDS believes are crucial to have in that protective order are that the privilege is waived only for the purposes of the ineffectiveness litigation to the extent it's necessary for the government to respond to the claims. 2, the privilege materials should be disclosed only to attorneys litigating and their agents litigating the ineffectiveness proceeding. And they should not be disclosed to any other attorneys or law enforcement. And then the privilege materials should not be used for any other purpose or in any other proceeding, including a retrial. And that we think would adequately protect the privilege. And the second thing that we think is critical guidance from this court is that the trial judge should, for pro se litigants, the trial judge should appoint counsel to pro se litigants as soon as this privilege waiver issue arises. Because as we saw in the facts of this case, Mr. Waters was appointed counsel at some point before the hearing started, but it was after the government had already secured an order from the judge that was a pretty broadly written order about the waiver of privilege. At the time that was done, he had no counsel advising him. And under Rule 4D of the rules governing 23-110 proceedings in this court, that rule does state that when the trial court shall appoint counsel when the assistance of counsel is required to effectively manage discovery, essentially. And we believe that that's the case here, because when typically what we've seen happen in these cases is the government typically will come in before it, when it's told it has to answer, it will come in and ask for an order confirming waiver of privilege. When the movement is pro se at that point, they really can't be expected to know the ins and outs of privilege and the scope and how this might affect them later, et cetera. And judges routinely grant those, and it varies from courtroom to courtroom, what the order says. And sometimes when the movement is represented, defense counsel will ask for protective order. But again, that is also, it varies because there's no guidance from this court. Different judges will either, some will.
Can I just ask procedurally here, am I right that when Judge Cannon said by filing the 23-110, you have waived the privilege, go ahead and talk to Dorsey Jones and his investigators, did Mr. Waters, even as a pro se litigant, get a chance to respond? I mean, it's possible he would have said, no thanks, I'll withdraw that aspect of my 23-110 if that's the consequence. But I couldn't tell from what I say. There's a written order that basically just says by bringing this 23-110, you have waived privilege. Was there any back and forth about that to your knowledge?
I don't know, Your Honor. Appellant's counsel may know. I don't think that there was anything filed on behalf of Mr. Waters. I don't think he filed anything, and he was incarcerated at the time, and so it's. I think that the order was issued pretty close in time from when the government filed the motion. So it's unclear to me whether he had a chance to respond or even.
Yes, it's funny. What the order says is, on consideration of the government's motion to waive any objection thereto, unclear if there was, and whether or not he had an opportunity. Because I would think if there was a waiver that was going to be assumed from raising a 23-110 claim, that he probably should give the defendant a chance to withdraw the 23-110 claim, knowing that the consequences about to attach to it.
Yes, that's right, Your Honor. That's right. So that's. I mean, I think that is a very good point, which supports, this court giving trial courts the guidance that they should not only enter a protective order. So there is an enforcement mechanism for protecting the privilege, but also that they should appoint counsel to pro se litigants before, at an earlier time than they have typically been doing so, at the time where this discovery and exchange of documents and waiver of privilege issue comes up, because it's a really it's a far-reaching, it's an issue that has far-reaching effects potentially on the movement, as we see in this case, right? He was required to turn over his privileged materials in fairness to the government so they could respond to his claims. And then what happens to him? He wins, and at his retrial, the entire trial is skewed in favor of the government, all because he vindicated his right to effective counsel. So I think
In this connection, by the way, how much of the defendant's counsel's file was turned over to the government? Was it the entire file, or was it only a limited portion of the file relating to the claims here?
I believe the whole file was, and appellant's
That's what I
counsel
believe
can
too.
correct
I
me.
mean, when you think about it, well, we've thought about it enough. All right, let us hear from the government, and we'll give you the opportunity in rebuttal that you requested.
Thank you.
Good morning. May it please the court, Michael McGovern on behalf of Appellee of the United States. The trial court did not err when it permitted the government to impeach two defense witnesses with their prior inconsistent statements they had made to defense investigators, because the statements themselves were not subject to any privilege, and the government limited its use to the impeachment of those witnesses. Although the witnesses' statements were contained within memoranda that were subject to work product protection, the facts detailed in those memoranda, the statements of the witnesses, were not themselves privileged. Moreover, the government only used these prior statements for impeachment of witnesses appellant himself chose to put on the stand despite being fully aware that the witnesses' prior non-privileged statements had been aired on the public record rather than to prove appellant's guilt in its case in chief. In a case where Judge Cannon recognized the entire case was surrounded by the specter of contrived evidence. Given that the use was limited to impeachment and that there was no attorney-client privilege to protect these statements, use of those statements was not improper. First of all, work product protection was waived at the time that the materials were disclosed under the 23-110 proceedings. This court has recognized that even where materials are required to be produced, attorney-client privilege or materials are required to be produced in order to vindicate a right. For instance, in McCoy, where in order to provide an alibi notice or to present an alibi defense, one has to provide notice of that. The government is entitled to there's deemed an attorney-client privilege waiver of the materials contained within that alibi notice because it's being provided to the adversary. Furthermore, in this case, although there was no counsel at the time that the waiver order was issued by Judge Cannon, there was never any request, despite appointment of counsel later, there was never any request for protective order. There was never any request for sealing. And indeed, at trial, there was no objection during Moore's testimony when he was asked about the issues that appeared within the memoranda. Even if this court was to find that Bittaker, which is procedure, as Judge Deal aptly noted, is procedurally different in the posture of this case. Even if one conceded that Bittaker's limited waiver were to apply, here, we don't just have the production of the documents in discovery. We have the use of those documents at the hearing itself on the public record. And the contents of those documents, again, is not privileged. It's not protected by the attorney-client privilege. These statements are not protected materials. So when they appeared on the public record, although the memoranda work product protection might re-arise under Bittaker, the actual facts and substance that the government used at trial to impeach was not initially work product. The prosecutor did at retrial what it was required to do. First, it confronted the witness about their non-privileged statements. And when first of all, the witness actually adopted certain of those statements, both at the during the 23-110 hearing. And so during that 23-110 hearing, you have actual statements by Williams that she smoked her cigarette with appellant behind 2443 on the playground rather than down at 2714, which was the most critical point of impeachment in this case with respect to Williams. So you have her adoption at the 23-110 hearing of that statement that she made.
I mean, I
which
thought the most critical point of impeachment of Williams was when she didn't mention that she was with Mr. Waters when the gunshots rang out.
That was
Whether or
another-
not you're in front of, building A or building B in that complex doesn't strike me as the most important point of impeachment. But the fact that she didn't mention the gunshot aspect of the PDS investigator, right?
Your Honor, I believe that was also an important part of impeachment, was the omission of speaking about the gunshots. But the placement of where they smoked their cigarette was indeed relevant, particularly where his alibi defense was that he was down at 2714 or down the hill near Wade Road at the time of the shooting, whereas her statements to the PDS investigator placed him behind 2643, which is exactly where one of the government witnesses saw him peeking out from behind the building before another witness saw him shoot the decedent. And so his placement was indeed a very important point of impeachment and one that the witness adopted at the 23-110 hearing.
The discrepancy between the two is what? I think it's 110 feet at one point in the record. It says that's the difference between those two places, which is not a lot. I mean, I don't know how long it takes you to move 110 feet. I'm not that fast, but I suspect I could do it in 10 seconds. So, I mean, it just doesn't strike me as that big of a point in the scheme of things.
Well, Your Honor, there is a hill there, so I'm not sure. I don't believe that there's any record testimony about how long it would have taken. But the point is that when she testified at trial that she was smoking cigarettes with him down the hill at 2714, it is an alibi for him not to be up the hill near Bernie Place at the time of the shooting. But her testimony in the 23-110 hearing is that she had stated that she had been smoking cigarettes and hanging out with him behind 2643 Bernie Place, up the hill in the area that puts him much closer to where the shooting occurred, but also is contradictory of her later claims that he's down the hill. And this plays into the fact that there was also testimony about jail calls that were made and his statement, the defendant's statements to jail informants that he was procuring false alibi information. And so that point of impeachment, we do believe, is certainly important. As Your Honor noted, it was also important that the memorandum did not record any information that she had stated she was with appellant at the time of the gunshots. The Ninth Circuit's opinion in Bittaker doesn't address this situation. In fact, the majority of the cases that are cited by both appellant and amicus don't address the situation. They, first of all, nearly all focus their analysis on attorney-client privilege and statements of a particular defendant to his attorneys, and don't really do any analysis on work product. Although there is a footnote in Bittaker, it's merely a footnote and not explored. The differences between work product and attorney-client privilege are not explored in that opinion. And that's important because the posture of this case is after. Bittaker is looking, I believe that I was speaking about why Bittaker procedurally did not apply to the situation that the court has before it. And that is because Bittaker's analysis really goes to what is appropriate in order to protect the protections at the time that they're being disclosed in discovery. It doesn't, in fact, do the analytical work on a fact record that is necessary to determine what the scope of that waiver is at any retrial. Although it speaks to it, it had its detractors. And in fact, it didn't consider the differences between attorney-client privilege or work product privilege. And the only case—
By its detractors, are you talking about Judge O'Scanlan's concurrence?
Yes, Your Honor.
Which did not seem to really, I thought that was more of an issue of whether or not you should leave it to the court on retrial. But I mean, it was a concurrence. I guess there was somebody else who joined it. I forget who.
Correct. There were two judges. I think it's important to note that the procedural context of Bittaker, the real question before the court that it was answering was whether or not the district court even had the power to determine what the scope of the attorney-client privilege waiver was at the time that these materials were being provided, because only if the court had that power was it able to issue a protective order in order to vindicate and protect those interests, and whether or not the federal government could decide that. But it was very clear in the concurrence that they said Bittaker goes, it makes very broad statements, which are not necessary to its holding, about what use may or may not be made on retrial of materials, work product and attorney-client, work product only being addressed in a footnote and not addressing any of the differences between attorney-client privileges and work product privileges, or the fact that work product protection is a limited protection. And
but I mean, those differences don't seem so critical to the analysis that Bittaker articulated, which was essentially, we're not going to put a defendant in the catch-22 of trying to figure out whether or not to proceed with a habeas or 23-110 proceeding in our case, and whether or not that they shouldn't be in a position to, that they should basically restored to the position they would have been in had they not had to litigate. I mean, that would apply. I mean, the rationale of Bittaker would seem to apply, whether or not it's in a footnote or not, it would seem to apply of its own force to work product.
So again, Your Honor, I think the difference here is that work product protection goes to the memoranda itself, but not the non-privileged information within it. The non-privileged facts that are contained within that work product simply are not protected. So there is no protection to reassert itself at
What
the
facts?
end
What
of
facts are you talking about? When you say non-privileged facts, do you mean the fact that Ms. Williams said that?
Yeah.
That she that's a.
Yes, Your Honor,
That's
that
what
is
you're
a
referring to.
fact.
I'm having a hard time grasping the distinction.
Yes, Your Honor, the fact that she made a statement that was contrary, right? The statement that she made,
Sure.
and
I mean, they could definitely ask her about that, with or without the memo. I'm not sure they would have if they didn't have the memo. I'm not sure, and they certainly wouldn't have been able to impeach her in the way they did with the memo.
Well, certainly their having the memo was not improper to the extent that, one, it was properly turned over during the course of the 23-110 hearings. And then, even if it hadn't been properly turned over the 23-110 hearings, the hearing itself was not sealed. There was no request to seal it. And that information was on the public record. So a prosecutor, even if they had not received from 23-110 government counsel the memorandum, would have been able to receive the information from the public record. And therefore, that's why there is no work product protection that reasserts itself. Those facts are contained now within the record. There's ample evidence that there was a conversation that took place, and that conversation itself is not protected. And
it seems to me what you're arguing, in effect, translates into a contention that appellant waived or forfeited the objection to the government's use of the access to and use of the work product by failing at the 23-110 hearing to demand the necessary protections, to assert a limited waiver and so forth. I'd like to put I'd like to put that aside for a moment. Let's assume that we're beyond that we, for whatever reason, say the claim was not in that sense waived. Then it seems to me we have a situation where at trial, the government was able to use information it obtained through what we might call a breach, for the sake of the word, of the work product privilege that the defendant had. And your argument, it seems to me then, you have to argue that, for whatever reasons, that breach was permissible. And I take it if this were attorney-client information, you would not be able to argue that. You would not be able to say, well, there was a limited waiver of the attorney-client privilege, and now we got really good information from that, and the government was entitled to use it for an entirely other different purpose at trial. I take it you wouldn't argue that if it was the attorney-client privilege.
Your Honor, I don't think that it's clear that the case, but the court need not reach that here.
Well, I'm
And-
wondering
and-
if there's a difference between the attorney-client privilege and the work product privilege. I somehow grew up not thinking of it as a privilege, but we can call it that for present purposes. And I don't know that I have a clear idea what your position is as to why there's a difference. If the work product privilege is designed to protect anything, it's designed to protect an adversary from having the advantage of the work done by the party's attorney to build the adversary's case and undermine the case of the party who has the work product privilege. And I don't know that merely because there was a limited waiver that there's a strong enough argument for the government to be able to use the information obtained outside the 23-110 hearing.
So I would point, Your Honor, then to Simmons and the cases that this court has relied on since Simmons. And that, because in that case, what you have is very similar. What you have is a compelled, essentially, in order to vindicate a right, a defendant must give up his Fifth Amendment right to not testify against himself in order, right, pre-trial in Simmons to have a suppression hearing, or in Bob in this court, the ability to argue that consent in a sex case, one has to put on information prior to trial or show that there was prior consensual contact between the victim and the defendant. And so in both of those cases, that there is a limited waiver of those constitutional protections. And that waiver is required in order for them to vindicate another right, in order to present a defense, in order to seek suppression of what they think has been constitutionally withheld. And what this court said in Bourne and in Bob is that where you go onto the stand to testify to vindicate that right, when this now enters the public knowledge, we are not going to prevent, although under Simmons, we won't allow the government to use in their case in chief that information against you. We will allow, if you then get on the stand to testify and testify inconsistently, we will allow the government to impeach you with that information because we are not required to suborn perjury.
Do you
And the
think
same
there's a
concept-
difference between impeaching Ms. Williams and Mr. Moore with their testimony at the 23-110 hearing and impeaching them with information obtained from intrusion into the attorney-client work product and into the attorney-client privilege and work product by getting access to documents in the defendant's possession?
I don't see.
See, I take your point about Simmons, and there's cases that suggest that that indicate that the defendant can be impeached with the testimony given at the motions hearing. But does that mean, but I'm wondering, and that would suggest, I guess, that the government at trial could impeach Ms. Williams and Mr. Moore with their testimony at the 23-110 hearing. Perhaps that's so, that seems analogous. But I'm wondering how far that analogy extends.
Well, Your Honor, what I'll note is that testimony from the 23-110 hearing, which again is not protected, right? The testimony of those witnesses themselves are not attorney work product, but the only way the government was able to ask those questions at the hearing was because of the work product. But we now have a record that has created a non-privileged recounting of the details of that. And so the government shouldn't be precluded from using that in order to impeach when the defendant, who knows that all of this information, that all of these prior inconsistent statements, which again are not covered by the attorney-client privilege, have been aired on the public record, he is now walking into court saying, although the world knows that this inconsistent statement was made, that all of these multiple inconsistent statements were made.
Well, only those
including
people who
questions
happen to be at the 23-110 hearing, or who have had the forethought or for whatever reason to obtain the transcript, which probably is a null set, other than the government itself. I don't know how much weight can be placed on the fact that the 23-110 hearing was nominally a public hearing.
But Your Honor, the point being that this was aired, and the information was available other than from the work product memos, because it was put into the public record. So there was a source, the public record.
Suppose the
contained this
defendant
information.
had said, look, we want this hearing closed to the public because confidential, or at least parts of it closed to the public because confidential information is going to be disclosed. Would the defendant have been entitled to that?
So, Your Honor, that hasn't been briefed, and I don't think that at this point I could answer that, but there would have to be an entire hearing about whether or not it would be proper to close that hearing, particularly with, and I think the question with regard to attorney-client privilege versus work product would maybe produce a different result, because the contents, right, again, the facts contained within the work product are not privileged. They are not subject to any type of protection other than the fact that they're contained in a memoranda, which is itself protected. And so
in the end, it does sound, although you didn't seem to say this earlier, it does sound as if the government's position is that ultimately Bitterman and the other cases in this vein are all wrongly decided. That that what the courts in those cases should have said is that when the government gets this information at a 23-10 hearing, if there's a new trial granted, the government can use it.
So, Your Honor, I think what I'm saying is those courts didn't actually have before them the opportunity to consider on a record what would happen, because all of them were in pre-proceeding postures, other than the Pennsylvania's decision in Schimel. But even in Schimel, one of the important factors, they seem to believe that impeachment would potentially be permissible, except for the fact that in that particular case, the use was not limited to impeachment because the court instructed that the defendants, again, it's addressing only attorney-client communications, the defendant's statements to his counsel, which were 3 different alibis and defenses, when told to the jury was instructed they could use that to consider the defendant's consciousness of guilt. So that case, court
you reject the rationale that it's fundamentally unfair to put the defendant in the position where the ineffective assistance of his counsel results in the government's getting information it otherwise would not have gotten and using it against the defendant at the retrial.
Where that information is not protected by the attorney-client, where that information is not protected by any privilege, it's simply information. Yes, because Bittaker, for that point, relies on this concept of returning the defendant to the state he would have been. But we do know that if there had been any development of DNA evidence, any other things, there are multiple ways in which a retrial is not going to place the defendant in exactly the position that he was at.
That's
and where
the problem I have with the sweeping nature of the rationale. But there is something very disturbing about the notion that at the first trial, the government never would have had access to the attorney's work product. And no amount of arguing that the facts contained in that work product are not privileged would have changed that. And and by hypothesis, counsel would have called Ms. Williams and Mr. Moore and put on their testimony without their being impeached. But because counsel was ineffective, the ineffectiveness continues, as it were, and the government gets the opportunity to use counsel's blunder, to take advantage of counsel's ineffectiveness by using counsel's work product against the defendant. Does that
I think here, rather than the government getting a windfall, it's defendant who's seeking the windfall. It's defendant who's saying, I need a retrial because my first trial wasn't reliable, right? The underpinning of the ineffective assistance of counsel is that we want a more reliable trial by having a defendant represented by counsel. And what he's saying is, I want my witnesses to be able to testify unimpeached and not subject to the crucible of cross-examination, which is how we test the reliability of their statements, despite the fact that the world now knows that they have said something different. And that result is not required. And we believe that that interest in that reliability and testing these witnesses is the same interest that Bourne and Bob recognize allow impeachment for the defendant's statements when he is compelled to give them and give up his right to self-incrimination, or in multiple cases where there have been Fourth Amendment, Fifth Amendment, or even Sixth Amendment violations, where there are statements obtained from defendants, and those statements, although obtained in manners that violated the Constitution, are.
Mr. McGovern, your time has expired, but you haven't had a chance to address, and I'd like to ask you to take a minute or two to address the Jenks issue, since that was the subject of considerable discussion earlier.
Yes, Your Honor. The government does believe that the trial court did not clearly err when it found that the memoranda at issue were Jenks material and therefore would have been required to be turned over in any event. The trial court did conduct an inquiry. The inquiry they conducted was by reading the face of the documents and looking at the very specific language that was used, the length of the documents, the language that was used in it. And made a finding that the memoranda were both contemporaneously recorded and substantially verbatim. And I will note,
it's sort of funny. Could you just tell me what you think? Point me to the phrases that you think are substantially verbatim. I assume you wouldn't think the whole thing is.
So certainly there is some prefatory language in the memoranda about how they got to the location they got to. Sometimes there are times that they began their canvass and when they left the area, and those wouldn't be substantially verbatim statements from any particular witnesses. But other than the pronouns changing and moving from first person to third person, the statements that are made are that Kiki spent a lot of time hanging out with her. Anthony hung out there playing with her. It's not entirely sure what time this was. He's not the kind of guy to use public transportation, so she figured he walked to meet her somewhere. These are all very colloquial phrases and don't indicate that there is any type of selection or summarization that's going on here.
I mean, does the fact that it's not recorded for a few hours? I mean, I don't know. I think 1 to 7 hours? Is that the window we have for the Krupp memo?
Well, Your Honor,
does that change your view about whether or not we should read these as being substantially verbatim? Because those do not sound, doesn't look like it's transcript to me. Go ahead.
Well, Your Honor, what I would note is that the actual evidence is that they were recorded shortly after. That was the testimony of both of the witnesses. Although 1 to 7 hours was a general time frame that was based on a leading question from defense counsel, the actual testimony was that they were recorded shortly thereafter when the information was fresh. Also, both of the investigators testified that they had an obligation to make sure that their summaries were complete and accurate. And so that testimony came later. And it supported the prior finding that the trial court had made, and there was no resurrection of an objection that based on the testimony.
I don't think it was supported by any prior finding of a trial court. Are you talking about Judge Cannon at the 23-110?
I'm sorry, I meant that the investigator's testimony about the specifics was not originally the basis of Judge Isco's ruling. Judge Isco's ruling was based upon a review of the memoranda themselves. Right. And to the extent that that appellant now alleges that the testimony of the investigators was somehow contrary to the conclusions that he made, they didn't raise that objection after those investigators gave that testimony. So they never re-raised the objection to say, this testimony doesn't support the findings you just made.
Well, if I remember right, the trial court's ruling was, I'm looking at this memo, they must have written it down at the time and then later memorialized it, which I don't know. I mean, I'm a little bit dumbfounded how one could look at this memo and think that that is what happened. That somebody, and it turns out that there's, seemingly unimpeached testimony that it's not what happened. I don't.
And can I pile on there as well?
Yes,
Let me add to that. Along with that, what Judge Deal just mentioned to you, I want to know how, in light of that, you would address Lazo, where we found that absent compelling evidence to the contrary, when the court receives a direct assurance that someone didn't take notes during an interview with a witness, the court satisfies its duty of independent inquiry to determine whether or not the conditions of the Jenks Act have been satisfied. Doesn't this mean that when is here, we've got this testimony that there are no notes taken during the interview. We don't make assumptions and the material can't be jinx.
Well, Your Honor, I will note that the determination that it was jinx occurred before that testimony was given. I'll also note that this court has said that simultaneous recording is not required. And so the fact, if this court requires that notes must be taken at the time or else it is not jinx, then that means that it is in fact requiring simultaneous rather than contemporaneous recording, if there is no space. But here, to Judge Deal's question, I'll note that if you read the memorandum from Idell, it records not only the statements with Lorenzo Moore, but it records multiple interactions with multiple people, gives their names, the particular apartments that they're at, and in fact talks about locating individuals, locating Mr. Moore not in his apartment, and then recounting what apartment he did live at versus where they encountered them. And so I believe that if one reviews the entirety of that memoranda, that the judge's determination at that time that there must have been notes, that this would be incredibly difficult to reproduce, that this information, if one had it stored in, would be incredibly difficult to reproduce without notes, at that time was not clearly erroneous. And when the contrary evidence was introduced through the testimony of the investigators, there was no defense objection re-raising that this defeated the prior jinx, and there was no request to strike any of the testimony that had resulted or for a mistrial at that point. And so we believe that the court's decision was not clearly erroneous, and that therefore the material would have been producible under jinx. If there are no further questions on either of the issues, the government would ask that the judgment be affirmed.
Thank you. Mr. Kaplan, you have a few minutes for rebuttal.
You're on mute, Mr. Kaplan.
Mr. Kaplan, you're on mute.
I apologize. A few points in response to what the government said. First of all, I mean, this argument that the facts in the memos are not privileged, I think this is, frankly, a silly argument. It's sometimes said that, facts are not protected by work product, but that, statement is, like many broad statements in the law, is not really literally true. And if it were true, in a literal sense, what a witness says to a defense investigator, a government investigator, that's a fact, but it's also work product. And I think Hickman versus Taylor makes it clear that, in other cases, have made it clear that work product is not limited to what is physically written down on a piece of paper. And I think
I largely agree with you, counsel, but I mean, you would agree that if they wanted to say, Miss Williams, this without the memo, did you talk to an investigator in June of 2010 that was associated with the defendant? They could ask that question, right?
I think they could, Your Honor.
I mean, I assume that's, and I guess her answer would have been, no, we know what her answer is because we have that on the record. And then if they happen to know that that investigator was Miss Prutt, let's just assume it's through some alternative means, word of mouth. Miss Prutt is a blabbermouth and talked about it. And they put her on the stand, they could say, and what did she tell you? Did she say anything about being with him when shots were fired? And if she says, no, that didn't happen, you wouldn't have an objection to that either, right?
Well, I think if the government were to ask something based on, had a good faith basis to ask the question and had some good faith, non-privileged basis for asking the question, yes, I think the government could properly ask that question. But
how do you distinguish the government's reliance on post-Simmons cases where the defendant, for example, the defendant who testifies at a 23-110 hearing or at a evidence suppression hearing in order to assert his or her constitutional rights can be impeached at a subsequent trial?
A few points, Your Honor, I'd make that. First of all, most importantly, what we're dealing with here, and I don't think any of those the cases the government cites dealing with impeachment, we're dealing with is on point. And here we're dealing with a privilege, and the whole point of a privilege is you can't use privileged information for anything, including impeachment. The other point I'd make is the cases where the courts have permitted, for example, Miranda violation or information obtained in violation of Miranda that can be used for impeachment. But the rationale there is you shouldn't allow a defendant to say one thing at a hearing and then say something totally different at a trial. Here, we're not talking about a defendant. We're talking about a witness.
I guess the government's point is something like this. The defendant puts on a witness at the 23-110 hearing. The defendant knows what evidence is in the defense possession that could impeach that witness. And the government gets it at the 23-110 hearing, so the government knows too. So if the government then at trial wants to call that witness, do the same principles as in those post-Simmons cases apply to say, look, the defendant has taken the risk that the witness will be impeached. And in the interest of and the truth-serving function of a trial, the defendant can't use the privilege and as a sword to restrict the government's impeachment.
I think it's very different when it's the defendant and when it's a witness. I mean, the witnesses don't belong to any party, and it's sort of fundamentally unfair to hold the defendant accountable for a prior statement by a witness. And the other point I'd make is
why is that unfair, though?
Because it wasn't. I mean, people tell different versions of the same story all the time.
And I think the jury's mill to hear about all those impeachments and determine, all those different stories and determine what to believe.
And I think that the cases which allow impeachment are concerned about this sort of fundamental unfairness, fundamental manipulation of the process, which I don't think you have when you're dealing with a witness who's giving a somewhat different story. Let me make one other.
This gets to what I asked you earlier, I think, which was could the government have impeached Ms. Williams at trial with her testimony at the 23-110 hearing, in your view?
Probably, Your Honor. I would think that's the case. I don't, it's not what happened here.
Well, right, it may not, but I don't remember exactly what happened at the 23-110 hearing.
In fact, she didn't testify at the 23-110 hearing.
Oh, that's right. Yeah.
She did. Ms. Williams?
I'm sorry, Ms. Williams did. The investigator did not.
The investigator did not testify, but Ms. Williams testified and could have been asked at the 23-110 hearing about what she told the investigator and what she didn't tell the investigator.
Right.
And if that had been done, could the government then make use of that testimony at trial?
I would think that would probably not qualify as work product. If she said this is what, as opposed to this is what I told the investigator. If she said this is what happened, I think that would
no. But suppose she said, well, didn't you tell suppose at the 23-110 hearing, she would ask, well, didn't you tell the investigator X, or did you fail to tell the investigator that? Did you tell the investigator something else? So on and so forth. And that was explored at the 23-110 hearing.
Again, it's different from what we have here, but I would think that would be work product and it would be improper to use it at the second trial. One other point I'd like to make in terms of use as impeachment, and
I suppose the government, having had the availability of the work product at trial at the 23-110 hearing, had said to its police officers, all right, this is very interesting, go out and investigate. And the police officers come back and get all sorts of information and do all sorts of investigation because they had the advantage of seeing that work product. And can the government use that at trial?
Well,
use what the police officers learned at trial?
Bittaker would suggest that no. And Bittaker says the information should be compartmentalized and shouldn't be used for any purpose, presumably including furthering an investigation. So I think Bittaker, again, it's not this case, but I think the teaching of Bittaker would be that no, anything that came out that was privileged cannot be used for any purposes, either directly or indirectly, to assist in the prosecution of the defendant. The other point I wanted to make about the sort of the exclusionary rule and use for impeachment. I mean, the court has said, the Supreme Court has said, for example, there's no, we have the exclusionary rule to deter police misconduct, but there's no, for example, the Miranda rule is not actually in the Constitution. It's a court-made rule. So using balancing, looking at the exclusionary rule and the purposes of the exclusionary rule, in our view, it's not inappropriate. It doesn't, it won't lead to excessive constitutional violations if we allow this for impeachment, in part because Miranda doesn't say in the Constitution you've got to give Miranda warnings, but it does say in the Constitution you're entitled to effective assistance of counsel, and it does say you're entitled to a fair trial. And I think that distinguishes this from some of the other cases all the other cases that the government has cited.
It doesn't say anything in the Constitution about the attorney-client privilege being inviolate or work product.
No, Your Honor, it doesn't. But I think there's, the defendant is entitled to due process of law and to a fair trial. And as I think I referred to in the other portion of my argument, it would be fundamentally unfair and I think inconsistent with the Constitution if you had a system where the government gets to invade the defendant's confidential privileged information, but there's no reciprocal right. I think cases like Noble suggest that there's a constitutional basis for the work product doctrine, and certainly you can't have sort of a system where one side has access to the other's confidential information and it's not reciprocal. So I think that is another reason to distinguish those cases where sometimes improperly obtained evidence can be used for impeachment. Briefly, I wanted to mention the government in their brief repeatedly suggests that Mr. Waters somehow did something improper the government seems to suggest he was trying to get false testimony from other witnesses. That's simply nothing in the record that supports that. What there is in the record was quite clear is he was trying to have his attorney, who ultimately was found to have been constitutionally ineffective by not calling alibi witnesses. He was trying to get his attorney to talk to alibi witnesses, and he was reaching out to people to, hey, please talk to my attorney. There's absolutely nothing wrong with that. The government complains that, again, and this would have had to have been done at the time when my client was pro se, that there was no request for sealing of the materials at the 23-110 proceeding. Well, first of all, presumably the waiver, as I understand the government said, the waiver occurred when the materials were provided to the government. But Lambright, another Ninth Circuit case, deals exactly with this, and that argument was made that, well, the defense counsel should have asked for these materials to be sealed, and he didn't, therefore it's on the public record and it could be used. And Lambright said, no, that's totally inconsistent with the reasoning of Bittaker. And finally, let me turn to Jenks. The government says, and I'm not sure this is clearly articulated in the brief, but the government says that the defense counsel should have, I guess, objected or asked the court to reconsider its ruling after it became clear that the defense investigators didn't take contemporaneous notes. And, as I said, the court was adamant that this was his ruling. He didn't want to hear more argument. And I think under Laszlo and other cases, the court at the time it was raised by defense counsel had an independent obligation to on its own initiative to conduct an investigation. But it's important to realize that by the time this was in cross-examination of the defense investigators, that it came out that they hadn't taken any notes, and the jury had already, the damage was done. There was no way it could have been fixed at that time. And I do agree with the government. I think the trial court's reasoning for admitting the memos was principally based on simply at the four corners of the memos that, I've looked at this and I've decided by looking at this that these are Jenks materials. Therefore, they're admissible as Jenks. And so I don't think under those circumstances,
When the authors or author of the memo testified and contradicted the judge's supposition and the basis on which the judge had ruled, I take it defense counsel did not at that point raise an objection and ask the judge to reconsider the ruling.
No, you're correct, Your Honor. The defense, I mean, the damage.
Is that a forfeiture or waiver? Well, forfeiture. Is that a forfeiture of this claim?
No, I don't think so, Your Honor. Again, it would have been pointless that time that the trial court had ruled. But also, I disagree a little bit with you. I don't think that was the principal basis for the fact that notes weren't taken contemporaneously. Was the basis of the court's ruling. And the court said that was one of the bases. But I think its principal reasoning is I've looked at this, and this seems to me to be a contemporaneous, or this seems to me to be a verbatim statement by the witnesses. And I don't think that was correct at all. So defense counsel repeatedly raised the issue. And, Lasso and other cases are clear. Once defense counsel raises the issue, in Lasso, at least for one of the witnesses, the court remanded for a hearing, even though defense counsel had not explicitly said, you should hold a hearing. And the court said, that's on the court, on the trial judge. The trial judge needs to make an inquiry when this is brought to its attention. So no, I think it's clearly preserved. And, when this became clear, there were no notes. I don't think that was why the court decided what it decided. But when this became clear, it was too late to undo any harm.
Okay. Mr. McGovern, thank you. Forgive me, Mr. Kaplan, thank you. Let us hear from Ms. Sadaskar.
Thank you, Your Honor. I want to respond very quickly to 3 points that the government made on the waiver issue, and just after that, one quick point on Jenks. So starting with the waiver issue, I think this court should reject out of hand this notion that because the information came out on the public record in the ineffectiveness hearing, that the waiver was somehow, set in stone for all time after that. That notion has already been rejected by the Ninth Circuit in Lambright and by the Pennsylvania Supreme Court in Schmiel. And as the court said in Lambright, there's no reason to provide less protection for privileged information that's disclosed in the hearing on the ineffectiveness claim than for the information disclosed on that claim during discovery. And it would render, when there's a limited waiver over privileged material for purposes of the ineffectiveness claim, it's almost always going to come out at the hearing on the record, as it did in most of these cases, including Bittaker. And
of course, in this case, nobody spoke in terms of a limited waiver.
That's true, but
counsel and everybody else were treating this as, well, they didn't think about it and seem to have been treating this as a hearing as well. We waived it and the government gets everything, and we're stuck with that. No objection was made. Is that fatal to this claim?
No, I don't think so, because under the case law, it's clear under Bittaker and the other cases that we're urging this court to adopt that an implied waiver is narrow under law, whether or not there is
not under the district's law.
Sorry?
If you're making, not under the District of Columbia's law. If you're making it's not clear. In other words, if you're making a plain error argument, our case law suggests it's hard to find plain error if you can't cite a case from this court or the Supreme Court supporting the proposition.
Well, I guess what I'm saying is that when the government says that putting something on the public record makes the waiver broader, there's no support for that, because that information almost always comes out at a hearing. And as the court said in Lambright, it would render the notion of a limited waiver practically useless if it were erased just because you disclosed the information at the hearing. You pretty much have to in order to make your claim. So I want to push back on that. That's already been rejected, and the court should reject it as well. The second point that the government was making was about so-called fact work product and how it could you could potentially permissibly use facts contained within the work product. And there's 3 reasons why that is not proper here. One, the government has doubly waived that claim, which we explained in our brief, so I won't get into that. 2, this concept of the government being allowed to obtain facts within work product is not generally applicable in criminal cases, because unlike in civil cases, there's no broad discovery mechanism for the government in a criminal case. So this rule comes out of the civil context, like in Hickman, where you have, the parties can exchange interrogatories and requests for production of documents and that sort of thing. Here, there's no, other than Rule 16, Rule 26, and other, very limited exceptions like the crime fraud exception or something like that, there's no basis for the government to just go out and get discovery from the criminal defendant on the grounds that it's fact work product. And the only criminal case the government cites in support of this notion about fact work product is this case Parks versus United States. But in that case was not about government access to a defendant's work product. It was about a co-defendant's. It was a case with 3 co-defendants. It was a case about one co-defendant's attempted use of another co-defendant's work product in support of his own defense. So that's not a case about government access. And then even in civil cases, the Supreme Court made very clear in both Hickman and Upjohn that this notion of fact work product, whatever the contours of it are, it definitely does not apply to, quote, oral statements made by witnesses, whether presently in the form of attorney mental impressions or memoranda. And the court in Upjohn said that Hickman drew special attention, as when it was discussing this notion of non-privileged facts, it drew special attention to the need for protecting against discovery of memoranda prepared from the recollection of oral interviews. Those are heartland opinion work product documents. There's no fact within them that can be separated out as, pure fact work product as the government's claiming here. And there was certainly nothing in the memos here that could, even if this applied in the criminal context, which we don't think it does here, there's no basis for that.
I think ultimately the government is challenging the very notion of a limited waiver in this context.
Yeah, because these arguments are sort of their alternative arguments, that if there was no waiver of privilege, we could still use the information, which is just not right. There's no exceptions to the use of privileged information, at least the ones that they're propounding here. And then the last point that the government made is that it was proper for them to use the privileged information as impeachment at the retrial. And there's really no basis for that. It's nonsensical, first of all, because remember, the notion of a privilege is that it's protection against disclosure of information in addition to use of information, not just use, but disclosure. So, in the typical course, if information is privileged work product, the government would not, or any adverse party would not be entitled to even see the information to figure out, do we want to use this for impeachment? Is there a way that we can use this for impeachment? I
don't understand how that distinguishes the Miranda context. I mean, that is a privilege against self-incrimination.
Well,
they're not supposed to hear it in the first place. I think you could say the same thing is true there.
well,
But we permit impeachment with it.
Well, but in those cases, I have a few answers to that, but to start with, in those cases, the government did something and they have the information. They shouldn't have had it, right? But they do have it. And the exclusionary rule cases are based on a rationale that just doesn't apply here. So the exclusionary rule is intended to have, is used for its deterrent effect on police conduct on the streets, right? We don't want the police to violate people's constitutional rights. And the reason why the Supreme Court has made this distinction in various cases to say that the exclusionary rule prohibits use of the illegally obtained material in a government's case in chief, but not for impeachment, is that the additional deterrent value from excluding impeachment of the defendant is it's just not enough to overcome the need for a properly functioning adversary system, the truth-seeking function of the trial. And here it's a very different calculus. There's no, I mean, note that the government hasn't cited, and I'm not aware of a single case where the same rationale was used for the context of attorney-client or work product privilege. And I believe
It's
that
not-
is because
it does not seem crazy to argue that the same basic weighing of cost versus benefit applies here. The government could say, look, there's a tremendous cost. If the defendant decided to put this witness on and thereby, number one, waive to some extent the privileges, and number two, to allow the witness to be subjected to cross-examination at trial based on privileged information. Excuse me, at the hearing, at the 23-110 hearing, based on privileged information, then the defendant has taken the risk of doing that. And sure, maybe it would be nice in an abstract world if it were a limited waiver, but there's a tremendous cost that we're also taking into account, which is the loss, the blow that would be delivered to the truth-seeking function of the trial if the government can't cross-examine the witness at trial the way, by hypothesis, it could have cross-examined the witness at the 23-110 hearing. It's not obvious to me that same rationale or that same balancing of, should not apply here.
well, I wasn't sure if you were finished.
I'm finished.
Okay, so I don't think it applies here. Let me try to explain why. As a legal system, we have already determined that the privilege is something that is so vital to the functioning of our adversary system, right? The Supreme Court said in Nobles that the interests of society and the accused in obtaining fair and accurate resolution of the question of guilt or innocence demand that adequate safeguards assured through preparation and presentation of each side of the case. And the work product and attorney-client privileges are what protect that and make sure that the system functions properly. So for example, yes, there is some, I can understand this feeling you might have that stopping impeachment when you know that there's an inconsistent statement is somehow harming the truth-seeking function of the trial. But that calculus has already been made by the fact that we protect privileged information. I mean, there could be all kinds of privileged information in work product and attorney-client communications that's going to impeach a witness.
Well, sure, but I mean,
Right?
the balance might change if you've used it affirmatively, though. I mean, if you imagine kind of a starker contrast, let's say that in the PDS memo, what Ms. Williams says is alibi. Then at the 23-110, she says, yeah, alibi, I was there. And then at trial, she says self-defense all the way. Yes, he shot him. So something that's just wildly inconsistent. It's true that normally you want to get the defense memorandum initially, and we protect that as work product, even if it could be impeaching. But having affirmatively used it, having affirmatively used the story that it was an alibi at a 23-110 hearing, it's quite odd to say, and you're not, you are free to change and tell a totally different story, and nobody can say boo about it.
Well, I don't think it is, if it's privileged information that was revealed at the 23-110 solely, and the privilege was waived solely to litigate the 23-110. Remember, then the only reason, if none of that had happened, in this case, for example, if Mr. Waters' first counsel had not been ineffective, the government never would have had these memos, right? So the only reason they even know that there's this impeaching material and that they have these memos is because of the fortuity that Mr. Waters had ineffective counsel. So to then use that information that came out only because he had ineffective counsel against him in any way in the second trial is kind of, making a mockery of his right to effective assistance of counsel. And I want to go back to just stepping back for a second about what is a privilege. It's a privilege against disclosure. I mean, if there's a rule that the government can use privileged material for impeachment, but not in its substantive case, then how would that work? It would upend the entire
Well,
way
that's not quite, but if I could just interrupt you, the important thing to keep in mind here is that there was by the defendant, a waiver of the privilege for a purpose that the defendant presumably thought was worthwhile. So it's the defendant who has sort of exposed the privileged information. If the defendant had not done that, the government never would have had it.
That's right, but it was a limited
But
waiver.
here, and to say, I'm just trying to understand the ramifications of saying that, well, because the purpose here was to get a new trial and establish that defense counsel at the first trial was constitutionally ineffective, a violation of the defendant's constitutional rights, that is a reason to restrict the government's use of the information, the otherwise privileged information, that going to the reliability of the claim that the counsel was ineffective and so forth at the subsequent trial. I am trying to work my way around that, figure out what that really means and how sound a justification that is, and
Well,
what the
if you-
consequences are.
Sorry.
I gave a number of hypotheticals to Mr. Kaplan. And I wonder if in your answer, you could also address some of those. Because I wonder how, we're talking about both direct and derivative use, you could say, of the privileged information.
I don't think that under Bideker, there can be no disclosure.
Well, Bideker is not a decision of this court. I've read
No, I
Bideker, we've all
understand.
read Bideker. But we have to decide, do we agree with Bideker or,
I
not?
understand. You're right. So if you believe that the privilege waiver was limited and narrow in scope, limited to the disclosure and use of the materials at the ineffectiveness hearing, it makes no sense to allow the government to then use the same materials against the defendant at a retrial.
That is right. You're assuming when you say that, you're assuming the answer to the question. That's why I said the government is really challenging the whole concept of the proposition of a limited waiver here.
Yeah, well, and the government,
Normally, when you turn over privileged information to somebody, you can forget about asserting the privilege, right?
right. But that's for an express waiver, right? This is an implied waiver. It's implied in law because you can't, once you put your attorney's performance.
Well, there's a procedural problem here. I agree with you. I mean, I think we talked about this and I raised it earlier. There's a procedural problem with the judge just saying, okay, you filed this claim, there's a waiver, without sort of, and doing it as an implied waiver rather than as a express waiver. So I go along with that. But,
So,
in principle, that shouldn't have been that way. You should have an express waiver by the defendant. The government should say to the defendant, look, do you want to go forward with this 23-110? You understand, if you do, you're going to waive. Let's discuss what the scope of that waiver is, okay? But the defendant should be expressly waiving it, not implicitly waiving it. Though you can also have implicit waivers in other contexts, I grant you.
yeah, I mean, I think in this sort of situation, it's typically an implied waiver because you can't go, it's the fairness principle to the government, right? That they need
The defendant can
information
withdraw
to
his
respond.
23-110.
Sorry?
The defendant can always withdraw his 23-110 motion.
Yes, right, right.
Or just not rely on those witnesses or some variant thereof.
Right, but if he wants to go forward with it, he has, in fairness
the
to the
consequence.
government, he has to impliedly waive for this purpose. So going back to the impeachment, the government hasn't cited a single case where a privileged document could be used for impeachment. There is just no there's no impeachment exception to the doctrine of privilege. There's no case I'm aware of that holds that. And in fact, there are two cases that we cited that reject that. The first one is Schmiel, which is the Pennsylvania Supreme Court case, where the court said it was an error to allow the government to use as impeachment privileged information that came out at the defendant's 23-110 hearing. And then even in Hickman, you can go back to 1947 to see that the Supreme Court frowned on this notion that you could use privileged materials for some purposes, but not others. The court said at page 513 in Hickman that the problem with allowing the use of an attorney's work product is that it forces the attorney to testify as to what he remembers or what he saw fit to write down regarding a witness's remarks. And the court goes on to say, quote,
Hickman wasn't the waiver case, though.
well, Hickman is about work product. So
Yeah,
we're just
sure,
talking about work product privilege here.
But it's not
There's
a waiver.
no
It's
sorry?
not a waiver case.
That's right. But I'm talking now not about waiver, but about,
If the defendant had put on his attorney to testify to all sorts of stuff, that would be helpful to Hickman. Presumably, the prosecution would have, presumably there would have been a waiver and the prosecution could have looked into that work product, right?
well, the government's argument here, remember, is that if the waiver was limited, as in Bittaker, this is their alternative argument. Even if the information retained its work product privilege, the government argues, it could still be used as impeachment. So I'm explaining that in Hickman, which is about the work product privilege, the court says to use the work product for impeachment would make the attorney much less an officer of the court and much more an ordinary witness. So Hickman itself rejects the notion that there is an impeachment exception to work product. And it is not analogous to the exclusionary rule cases because there's no balancing about deterrence, and there's already been a decision made in the reason this privilege exists is because it furthers the proper functioning of the adversary system and the truth-seeking function at trial. So it makes no sense to have an impeachment exception.
So how far does this extend? If the witness at the 23-110 hearing gives testimony, and the testimony is in some way intertwined, as you could well imagine it would be, with the privileged material, can the government then make use of that testimony, that same testimony of the witness at trial, in your view?
I think there would probably have to be some litigation over how, when you say it was entwined with the privilege material.
Well, the person was asked about that, the privileged material at the 23-110 hearing. Didn't you say X? What about this question? Or just there's information here that leads the government to ask certain questions of the witness. It could happen in a million ways. And you have a record of the witness's testimony, which would not have occurred but for the disclosure to the government at the 23-110 hearing of the privileged information. Or the government makes use of that privileged information to do its own investigation. I gave a number of hypotheticals earlier.
Yeah.
At trial, all of that, in your view, does the fact that this is a limited waiver prevent the government from making use of that same testimony or that same investigation at trial?
If it comes from the privileged material, yes.
So
If
it's
they get it
derivative.
some
So you're
other way.
making an argument of both direct and derivative immunity.
Yes, yes. So
Yeah.
if they can show that they got it in some other way that's not connected to the privilege,
Oh,
I think that would be a different issue. And the last thing I want to say is just,
Well, let's see. So you don't think if there's testimony by the witness at trial that is in some sense not it's funny because without that work product, the witness never would have been on the stand at the 23-110 hearing. The only reason but all right. So if but let's assume the privileged information was not used directly in questioning the witness, but the witness testifies at the 23-110 hearing. Can the government use that testimony at a subsequent trial?
not if the witness is divulging privileged information, no. And the last point I want to make is
Well, that
that,
gets to the government's argument that the facts are not privileged. So, in other words, the witness testifies, Ms. Williams testifies, here's where I was when the gunshots went off and he was with me and we were down the hill or up the hill. And we were smoking cigarettes and all this stuff at the 23-110 hearing. And then a trial, the witness deviates from that testimony. Can the government use it to impeach the witness?
no, because it still came from the privileged material, right?
That
So-
strikes me as a very, you may be right, that strikes me as a very far-reaching consequence here. And I sort of wondered whether there was going to be some reining in of the limitation imposed by the by the so-called limited waiver of the privilege.
Well, I
But
think it
you're
helps
not
to
going
look-
there. You're not giving me a reining in.
Well, I think it helps to think of it at, I think the reining in is that the government, nothing can stop the government from, talking to these witnesses themselves or getting.
Well,
the
oh,
information.
okay. So suppose the government, having heard the witness's testimony at the trial and having heard all this privileged information and so on and so forth, sends its police officers out to talk to that witness. And obviously they know what to ask. And they get all sorts of information directly out of the witness's mouth. Can they use that?
Well,
It all has this quality of being potentially, if you will, tainted, if you want to use that word, by the exposure of the work product. Or
yes, and that's why our argument is, that you should follow the Ninth Circuit's case in Bittaker, which restricts disclosure, the privileged information shouldn't even be disclosed to other law enforcement or other attorneys who are going to be working on the retrial. And I think it helps to remember in terms of, if you're thinking this is broad, I don't
so
think
in other
that's the
words,
right.
wait a minute. So you're saying, what you're saying, I think, is that, am I right about this? Maybe I'm misunderstanding you. Are you saying that the government's attorneys for the retrial should not even have access, in effect, to the 23-110 hearing transcript?
Correct. Well, at least not to the portions of it that reveal privileged information. There may be some portions of it that don't reveal privileged information, and that would be fine. But the privileged information has to be protected. And remember that the purpose of the narrow
The
scope
privileged
is,
information is, I'm not sure I understand. What is the privileged information? In other words, the defense, through defense investigation, the defense has a statement of the witness. They've learned everything that they think the witness can say. Okay, and it's helpful to them, so they call that witness. And by virtue of having done that legal work and having done that work product, they put the witness on the stand, and the witness, let's say, testifies pretty much in accordance with what the witness told the defense investigator. Is it your position that the witness's testimony, therefore, should be withheld from the entire testimony, the witness at the 23-110 hearing, should be withheld from the government lawyers who are going to retry the case, and they can't use it for any purpose?
any portion of the witness's testimony that would have been privileged had it not been.
None of it would have been privileged, and the witness is just saying, here's what happened on such and such a date when I was.
Okay, if it's not privileged, then I think
but-
that's different. I'm talking about privileged material. And
Give
remember,
me an example
in-
of what you mean by privileged material.
so in this case, the privileged material is the memos, the information in the memos. None of that should be disclosed to the people doing the retrial. And it's because we want to put for the second trial, we want to put the defendant back in the place that he would have been in had he had effective counsel with respect to privilege. Okay, so the idea is that the privilege should be restored to what it would have been had he not had to vindicate his right to effective assistance of counsel. I think that's the best way to look at it. So if it seems broad for the retrial, it's no broader than what what the first trial would have been if the person had had an effective counsel, because all of those memos would have been privileged. The government never would have gotten them. So we're just trying to put the person back in that same original position that he would have been in with respect to his privileged materials being protected. And the last thing I want to get to, because I know I've gone on very long, is this notion that the government can get privileged material to use for impeachment would upend the entire way the criminal system works, right? Because it would be almost like a reverse Brady obligation. Like, does the defense then have to go through its files and turn over, privileged material if it's potentially impeaching? I mean, it would just, there's no such animal in the criminal context, or when it comes to privilege. There's no impeachment exception for privilege, because privilege is a protection against disclosure. There's no case or anything that I'm aware of that says that you have to turn over privileged material to the adverse party so that they can determine whether they can use it for impeachment. It just goes against the entire bedrock notion of what a privilege is. So unless you have further questions, I think I've taken more than my time.
No, well, I was the one who kept you going. So it's on me.
Thank you.
Counsel, thank you all very much. The case is now submitted, and you may all log off. We will now call the second case on our calendar, Stuart Anderson versus DC Department of Employment Services.
Good morning, and thank you very much. May it please the court. This is actually, although the record may not seem it, an incredibly simple case in which the agency is trying to administratively overturn this court's decision in Safeway versus the Department of Employment Services, which is 832 A. 2nd 1267. Usually when I'm here, I get counseled that my job is to talk about the decision of the CRB and not the decision of the ALJ. But in this case, the CRB at page 6 of its order specifically adopts the reasoning of the administrative law judge. So I think that this court is left with the responsibility to look not only at the order of the CRB, but the order of the administrative law judge, which in my opinion on these issues is incomprehensible. I've read it so many times. I wish I could tell you exactly what it says, but every time I read it, I think it says something else. If you look at the bottom line of the CRB's order, the only issues that they affirmed were the finding of the administrative law judge that Mr. Anderson's claims for medical care only, were barred by untimely notice and untimely claim. This is a very crafty way to try to overturn the Safeway decision, because if the CRB got to whether or not Mr. Anderson's hip conditions are the result of what happened in 1984, the failure to apply the presumption would have absolutely required reversal by the CRB. But rather than get into that, they simply affirm these unsupportable holdings on notice and limitations. I'm going to start with notice because it's uncontested. This court said that notice does not bar a claim for medical care, plain and simple. Yet the CRB affirms a decision which they acknowledge the parties say is uncontested. If you look at the CRB decision at page 3, the CRB said that the employer and insurer say the claimant is correct that the failure to comply with the timely notice requirements does not bar a claim to receive medical care. So it's conceded that notice is not a defense, yet the CRB affirms that in the face of this holding by this court in the Safeway decision. The second thing they find is that Mr. Anderson's claim is barred by limitations, right? And they adopt the holding, the logic of the administrative law judge, which is at page 6 of the order, which is basically one paragraph where the ALJ cites the statute and says the claim is barred, cites no evidence, does no statutory or regulatory analysis, and finds the claim for medical care and medical care only is barred by Mr. Anderson's failure to file within 1 year. And so the CRB, while adopting what the ALJ said, gets into it a little bit on page 4 of the order when they talk about the Moore case. And I'm going to come back to that in a moment, if I may, Judge Glickman. The Moore case does not overturn in any way, shape, or form what this court, what Professor Larson, what the United States Supreme Court, what public policy all say about medical care and the workers' compensation setting. If you start with the statute, which is, I think, where we have to start, and you're looking at whether or not Mr. Anderson's claim for medical care only can be barred by the failure to timely file a claim, you look at 32-15-14, which says you got 1 year from the date of injury to file the claim. And you look at 7 DCMR section 203.3, which says, before the statute of limitations can begin to run in the District of Columbia, the employer must file a first report of injury with the agency. Now, you won't find a first report of injury in this record, and that's not some oversight. There's no first report of injury ever done. And the employer's argument is that, well, he didn't give notice, so we could never file a first report of injury. And therefore, even though we didn't comply, the statute runs without us doing what we're supposed to do. And that may have some appeal to this court because it doesn't ever put a cap on when an employer is responsible for medical care, but that's actually what the statute is intended to do, as this court pointed out in the Safeway case. And if we look at the Safeway decision at pages 1269 and 1270, this court went very carefully through the difference between compensation and medical care. And the court cited the definition of compensation from 32-15-016 as being the money allowance payable to an employee and his dependents, which includes federal funeral benefits. And then went on to cite the definition of DC Code 32-15-07 medical care, and specifically said, under our act, we have held that medical benefits are not subject to the same limitations as disability income benefits. And went on specifically to say that when it comes to these limitations related to notice, that untimely notice did not bar a claim for medical care. You cited Professor Larson for that, because Professor Larson says medical care should be different. This court cited the United States Supreme Court's decision in Marshall versus Pletz, in which the Supreme Court held that the furnishing of medical aid is not the payment of compensation. And there's a basic public policy reason for this, right? When medical care has its genesis in an injured worker's employment, the employer and its workers' compensation insurance should bear the cost of that medical care, not the taxpayer, right? Because if folks are left without medical care and aren't able to work, this medical care, rather than becoming the responsibility of the employer or the insurer, becomes the responsibility of the public tax dollar. And I think that's why medical care is distinguished from monetary compensation in workers' compensation systems all across the country. But this court has already said that medical care is not the same as compensation in this setting. Now,
May I ask you a question? May I ask you a question if I may. You referred to the regulations,
Yes.
and as I read the regulations, for purposes of 32-15-14, the term claim is, seems to be defined as including a claim for medical care. And I'll, if I can, let's see. You know, when I have to use two computers at once, it's a little hard for me to do this in an efficient way, so you'll forgive me, but claim is defined as a claim under sections 15, under 32, 1507, 08, and 09. And 07 is a claim for medical services. So that suggests to me that the regulations understand the 1 year limitation in 32-15-14 as applying to claims for medical services as well as to other claims, notwithstanding that the statute uses the term compensation. Do you have a view on that?
I do, and I want to
It would
look.
take me a minute to get the definition in the regulations of claim, because I'd appreciate it if you would find it fair. You probably could find it faster.
I had it up earlier this morning.
Let me see if I can get it real quick. So if you go to its regulation 7-299, that's the definitions section of the regulation. And definition of claim given there is an application for benefits made by an injured employee or his or her beneficiary under section 8, 9, and 10 of the Act, paren DC code. Now it gives the old section numbers, 36-307, 36-308, and 36-309. And I think 36-307 is now 32. 1507, which is the medical services section.
To read it, so I understand what your question is. When the regulations define claim as anything other than, as everything that might be payable by an employer in a workers' compensation setting, does that somehow change the limitations period? I don't know how it can, because that would be executive legislation, right? Because the plain language of the statute only applies the 1 year limitation period.
When you said plain language, it applies to 1 year limitation period to claims for compensation. But in Moore, we recognized that from section to section, the definition of compensation may vary. And Moore distinguished Safeway. Now, Moore, of course, was a different situation, but my thinking is, gee, the CRB looked at section 1514 and for policy reasons having to do with, not completely eliminating the statute of limitations, concluded that it applied, that compensation in that section encompassed claims for medical services. And the regulations seem to lend some support to that interpretation. And that's why I'm asking you how you react to that. And we have a tendency to defer to any reasonable interpretation, but I wouldn't say any, to a reasonable interpretation by the CRB of ambiguous language in the statute.
So first of all, the CRB's suggestion that there's no limitations, if that's how the court is reading it, it is untrue. Because obviously, no matter what happens in this case, Mr. Anderson's failure to give notice within a year on if there's a repetitive, and this is what makes this decision so incomprehensible, because what you're talking about, there's still the 1984 claims. There are two of them in which claims were actually timely filed, yet they weren't disposed of, right? So we focus on a claim that wasn't filed, and I'm going to answer your question in a minute, but this is where it gets complicated. The ALJ found that the date of injury in this case should have been November 28th, 2014. There's no claim filed for November 28th of 2014. So the ALJ is ruling on something that doesn't exist.
Well, I think if I can just stop you there,
Sure.
I understood, I may be wrong about this, but I understood what the ALJ in effect to be saying is that it appears that it was in 2014 that Mr. Anderson, or that may have been the latest date actually, that Mr. Anderson actually knew or should have known that his hip problems were attributable to the to his football playing back in the 1980s with the Redskins. And that seems to be supported by Mr. Anderson's testimony at trial when he said that he knew in 2014 that that's when he knew that, or he did know, and supported by the fact that he actually filed a claim of sorts with the NFL's program. I don't know why he didn't file it also with his employer, but
Well, he did.
so,
He did. His employer is part of the NFL Management Council, and that record.
that argument hasn't been made. The argument has not been made that he notified his employer,
Right.
that he made the claim to his employer in 2014.
And it's sort of that. And again, I don't think this is before the court, but it's what makes this case impossible to decide on this record, because in a cumulative trauma case, this court knows that the date of accident is the earliest time that the person either sought medical care or lost time from work. And so even the ALJ's finding that the 2018 date is when he sought medical care is unsupported by the evidence, because in the same sentence, the ALJ talks about the August 25th, 2017 medical evaluation he went through in conjunction with this disability application.
Something I was going to ask you is when do you claim, or when does Mr. Anderson claim he first knew or believed that he had, or should have known that he had sustained the hip injury from playing football for the Redskins?
In 2014, with regard to both hips on July 26th of 1984, and with regard to the right hip on September 10th of 1984, both of which he timely reported and filed claims for. But we're kind
not
of,
with his employer.
yeah, oh no, he filed claims with the agency. He actually got medical care from the employer's training staff in 1984 for hip injuries.
I thought you said it was in 2014.
Oh, I'm sorry, 1980. The problem is so long ago. I was still in law school. 1984. So there, he had hip injuries in 1984 that he reported to the employer and that he got treatment for from the employer. The notice finding on those two claims is sort of craftily swept under the carpet by the ALJ, saying, well, those were groin injuries, without applying the presumption, in spite of the fact that our medical evaluator said this degenerative disc disease was the result of the natural progression of the injuries that first manifested in 1984. That's why this is a crafty decision, because the question you're asking, they didn't analyze whether or not there was any causal connection between his current hip condition and the injuries which are of record. And listen, there are factual findings that have to be made as to whether or not his current hip condition is a continuation of the hip problems he had with the Redskins then in 1984, the Commanders now. However, that wasn't addressed by the court. The only claim they addressed was the 2018 claim, and they addressed that wrongly. Now I want to go back to the question that you asked first, Judge Glickman, which was, doesn't the regulation somehow mean that the 1 year limitation applies to medical care for making a claim. How can it? Because that is different than what the statute says, right? The statute says a claim for disability. That's very, very clear. The words in the statute are except is otherwise provided, the right to compensation for disability or death under this chapter shall be barred unless a claim therefore is filed within 1 year after the injury or death. The reading that you're asking me to adopt, Judge Glickman, is executive legislation. You cannot change by regulation the plain language of the statute. It clearly only intends to apply to compensation. And the Moore case is completely consistent with that. There are exceptions to every rule. And in Moore, the claimant was overreaching, right? The claimant was trying to double dip, and this is what makes bad law, right? The claimant had already got benefits and tried to use that definition of compensation to excuse him for repaying the employer for benefits it had already provided, right? So that case was so limited in facts. It was about a lien. And when you look at it, and actually the CRB says in its last sentence, we understand this was to protect an employer from not getting reimbursed for money they paid and to prevent double dipping by the claimant. That has nothing to do with medical care, which every court who's ever asked to look at whether there's any limitation on medical care under this statute has said no. And I'm sorry, Your Honor, this paragraph that we're talking about, if this is the CRB's analysis of why this court should find compensation includes medical care when it comes to a limitation for filing a claim, but not a limitation for giving notice, there's got to be a heck of a lot more of a record developed for you to say this is a reasonable interpretation, because there is no explanation other than them saying, well, in this one limited situation where a claimant overreached, we found compensation meant something different in that fact pattern. And if you look at Moore, it says this is very limited. If the court adopts the limitation that is urged by pro football here, every latent injury that a football player suffers that doesn't manifest for years or decades is going to be excluded because people don't know, right? They don't know where it came from. This whole cumulative, the CTE stuff, most everybody would have been excluded when they first started getting treated for medical care because nobody knew about the connection between employment. And there are all kinds of.
Well, I thought the statute speaks in terms of knowing or, in effect, learning facts sufficient to, the statute isn't going to run until one can say that the employee should have known.
Well, and in this case,
right?
In this case, way after a year, Mr. Knowing that he has a hip disease and knowing that he has a condition that requires bilateral hip replacements are two different things, right? And we don't talk about that in the record either. And this record isn't developed enough to say that on the 2018 claim. This record gives no facts, not a single fact that could support the finding that either the September 26, 1984 claim or the September 10th, 1984 claim should be barred for untimely notice or because of limitations. It's simply not addressed. There are three claims Mr. Anderson pled alternatively, and you'll see that in the record. And the administrative law judge wasn't that pleased with me. And you'll hear the ALJ say, well, you made the mess out of this record. You deal with it. Well, quite candidly, Mr. Anderson didn't make a mess out of this record. His factual situation made it complicated, but that doesn't make application of the law complicated. So I want to go back to.
Let me read you Mr. Anderson's testimony. See, I've been thinking that at the latest 1 year time period of this is passing the question of interpreting, which I recognize we've been discussing. But if we assume that claims do have a 1 year, claims for the medical care like this do have a 1 year period, it would seem as if the time period at the latest began in 2014, because at the hearing, Mr. Anderson was asked, and this is a transcript page, I think 147. When you filed that total and permanent disability application in 2014, and that's the application that he filed with the NFL, I think, if I understand correctly, the Pete Rozelle program. You did so because you believed that your bilateral hip condition was caused by your employment with the Redskins. And his answer was yes. And my understanding is he didn't file a claim within 1 year of 2014. He waited until I think it was 2019.
And I think that if you read his testimony in total, and I'll look at it while I'm waiting. He said repeatedly, this is the same problem I've been having since back when I played with Washington in 1984. And his feeling and his belief as he sits here today, and he's probably watching this.
Well, 2014 was the latest.
I'm sorry.
It could have been.
I apologize.
He should have. Right. I mean,
dating back, he relates it back to 1984. I'm sorry, 1984, when he was employed by Washington. And he said repeatedly in the hearing, this has been going on ever since I was with the club. And in his mind and in his belief, and as you'll see in the record, he's a UVA educated guy, right? And he says, I told them about this in 1984, and this problem's been going on ever since, and they knew. And he didn't think he needed to do anything more than file claims and have his hips looked at in 1984, so that in 2018, when he found out that he needed bilateral hip replacements, he could go back and claim it, and he did claim that. But because we knew that the club was alleging this had nothing to do with 1984, we filed a cumulative traumatic injury claim. Because if they're going to take the position that the care that he got in 1984 was not related to the hips, well, then those evaluations for his long-term disability are not medical care. That starts the statute of limitations. And it's only in 2018 when someone says to him, you need surgery that's going to disable you. You need actual medical care. There's no medical care recommended in either of those evaluations. And so in 2018, you have a medical report saying he now needs medical care, bilateral hip replacements, first time. So the ALJ rejects, and how what the ALJ is saying is that somehow the notice requirement, right? And there's a case like this that this court decided. Thornton, I think it's a Metro case with a guy who tacked upholstery onto seats. And he knew for some time that it was bothering his wrists, but he didn't become disabled by it until sometime later. And the ALJ said, well, he knew about it before, so he should have given notice. And the argument was, notice of what? Right? Until there's a claim, you can't have a notice obligation. The notice requirement begins on the date of the accidental injury. You can't give notice of something before it legally exists. And so what the ALJ has in.
Are you saying that in 2014, for example, he was not obtaining medical care for his hips?
He was not. You look at the reports, he was getting an evaluation for a permanent and total disability policy provided by the employer. And if you look at the x-ray findings at page 829 of the appendix, you'll be interested to see the findings in that x-ray, in that evaluation in 2014 are virtually identical to the x-ray findings in 1984. The only thing they found wrong with his hips at that time was some moderate narrowing of the joint spaces. The exact same thing that the Redskins had found in 1984 when they did an x-ray of his hip. So yes, that's not medical care, and that doesn't start the statute a-running for a cumulative trauma case in the District of Columbia. So it's either when he got medical care in 1984 for his hips, in which case there's no notice or limitations problem, or it's in 2018 when he's told he needs bilateral hip replacements, and the ALJ declined to analyze either ends. The ALJ picked the point in the middle, said, something happened in 2014. Well, there's no claim for 2014. He had no obligation to do anything in 2014. That's why I said it's a very crafty way to get around deciding the simple case. There's a simple way to have decided this case. Figure out whether or not the hips have anything to do with the employment, apply the presumption, say the hips aren't related to the employment. Then all this procedural stuff goes away, but they're asking you to take a dangerous step to put limitations on medical care where there's no statutory support for it, which is at complete odds with the authority of this court, with Professor Larson, with the Supreme Court, and with public policy, because the Mr. Anderson's hip replacements are paid for by Medicare or Medicaid, the public tax dollar. That's not what the workers' compensation statute is designed to do. And that's why the workers' compensation statute separates money benefits that are paid to a person from medical care, which is going to get provided one way or another, right? And so to read compensation to include medical care when there's a limitation on that based on notice, separately than compensation for medical care when there's a limitation based on time of making claim, creates a complete dichotomy in how this court distinguishes compensation as it's used in the statute, not in the regulation. And I think if we're going to rely on the regulation to modify the statute, I think that's an impermissible exercise of executive power.
Can I
And
just
so-
ask, because
I'm sorry, go
you've
ahead.
cited to Larson a few times in your argument.
Yes.
You actually didn't cite to Larson in your brief. I assume you're pointing me to the same passage that we quoted from in Safeway stores.
Well, yes, because Larson, Professor Larson, he wrote the Horn book on workers' compensation, Judge Deal. And you'll see Larson agrees with this court's finding on Moore, right? Because you can't use the definition of compensation to create an absurd result. Allowing double compensation and double dipping is absurd. And when injured workers double dip, it creates bad law for all the folks who don't double dip. And that's what Moore was trying to do. And you have to give the agency discretion to fix misuse of the statute by either workers or employers. And that's what they did there. They have not changed the definition of compensation from the statute, which talks about the money allowance payable, by saying a claim includes everything when you're talking about a global settlement of a workers' compensation claim in a third-party case. It has nothing to do with what we're talking about here. But yes, I am talking about Professor Larson and the passage you quoted.
Let us hear from counsel now for the interveners, and we'll give you a few minutes in rebuttal.
Thank you, Your Honor.
May it please the court, David Dumrick on behalf of the interveners, Employers Pro Football, Inc. and its insurer, Fireman's Fund Insurance, Alliance Reinsurance of America, Inc. I would agree with Judge Glickman's analysis that really for medical benefits, you need to file a claim. It's not merely notice, but it's also a claim, and it's a significant issue. The hearing record indicates that claimant knew his bilateral hip injuries were caused by playing football on November 28, 2014. The hearing testimony indicates he was evaluated by NFL disability doctors, and that he was aware that he had changed his prior disability forms with the NFL Players Association. Previously, he didn't ask for bilateral hips as part of his disability. He didn't say he had bilateral hip problems. But after November 28th, 2014, he does. And specifically, I think that's the trigger that the ALJ used to determine when he was required to give notice within 30 days and when he was required to file a claim within 1 year under the statutes. The direct quote was a cross-examination by Great Divide Insurance Company at pages 147.5 through 11. And they asked him about the NFL Players Union disability paperwork that he filed. And the question was, and my understanding from your prior deposition testimony is that when you filed that total and permanent disability application in 2014, that would be November, I'm adding this in, i.e. November 28th, 2014, you did so because you believed that your bilateral hip condition was caused by your employment with the Redskins. And his response is yes. So the judge—
I have understood Mr. Boscolo to be saying a few minutes ago is that he knew he had, the Mr. Anderson knew he had had hip disability resulting from his playing days with the Redskins. And he knew that in 2014, and he in fact knew it before then, but that he did not have any claim for medical expenses to file until he was advised in 2018 that he needed surgery. How do you respond to that?
I think the ALJ was correct that she triggers it as far as a claim is when he knew that football caused his bilateral hip conditions. And he knew that because of doctors telling him. He knew that from the NFL doctors. He knew that because he had prior x-rays. He had been in contact with doctors, and there's records of doctors in the medical records indicating that knowledge and him figuring it out by that point. And once
What
he
claim would
figures
he
it,
have been making before 2018?
and you broke up, Judge Glickman. I'm sorry if you could say it one more time.
What's the claim he would have filed?
I think you'd file for bilateral hips. If you take claimant at his face value, he testifies in the hearing that he had bilateral hip problems going back to 2014. He testified at the hearing.
I don't know what you mean by for bilateral hips. I mean, do you mean for bilateral hip replacement surgery that he didn't know he needed to have yet? Do you mean a claim for some? Is there record evidence that he required some earlier treatment? What claim was he going to file in 2014?
Well,
I mean, if he's assuming
let's use claimant's
disability
own
is
words. Let's use claimant's own words, because I think that's the way we answer that. At the end of the hearing, the administrative law judge at page 160.19 through 21 of the hearing transcript specifically asks claimant, question, after your football career, when did you begin to think that your right hip pain was caused by playing football? Answer, well, I knew it all along. Question, and the same thing for your left hip? Answer, yes. So claimant knows all along that his hips were caused from playing football. Now, we don't agree with him, but that's what he knows. And what's really important, I think you need to go to the DOES supplemental exhibits that were filed on February 15th, 2022 with the court, and look to Fireman's Fund Exhibit 6, which is at DOES pages 36 and 37. And there's a letter from Dr. Donald McNay on June 17th, 1987 to claimant's attorney, Gerald Herz, back at that time frame. And in that letter, Dr. McNay opines the groin injury of 1984 is healed without residual dysfunction, and the x-rays of the hip and right pelvis are within normal limits. So based on that, the medical documents provided to claimant's counsel at that time shows that there's not a hip problem. They're within normal limits. I mean, now I understand
This really gets to an issue that's not before us, I think. The ruling before us is purely a ruling based on issues of notice and claim timeliness. Although the ALJ also made findings about causation and the like. Those issues, I think, are not before us in this appeal because they're not the basis for the CRB's decision. Am I wrong about that?
You know, I understand, but both the CRB recognizes that the IME doctor says that he has congenital hip problems. And in fact, the IME opinion by Dr. Louis Levitt indicates there is no radiographic findings of evidence of traumatic arthritis in claimant's hips. And he has congenital defects of dysplasia, and that's the cause. And I think it goes to rebutting the presumption of compensability, that the ALJ looks to what are the contemporaneous medical records going back to 1984, and do they indicate ever that there's a hip injury?
Well,
Our
I think
position is no.
you may be arguing that, if I understand you correctly, then you're arguing that the employer here was not on notice of any hip injury. And I think you may have a strong argument there. But the question here is a different one, I think, which is whether the claim that he made in 2019 for medical services relating to his bilateral hip injury, which is to say his right and left hips, was timely or not. And indeed, whether it was covered by the 1 year, whether it was subject at all to the 1 year statute of limitations. Mr. Boscolo, if I understood correctly, is arguing that before 2018, he had no claim to file because he wasn't seeking any medical services and nor was he seeking this other kinds of benefits with respect to his hips before that, before he was informed that some sort of surgery would be necessary in 2018. And I'm wondering if you think that's right, or is it your position that once he knew, or once he believed that his hips had been damaged by his playing football, he had 1 year to so inform and make a claim to his employer? And if so, what would the claim have been?
Well, it would be for bilateral hips. He put his employer on
What does
notice.
that mean to say bilateral hip? He writes to the employer and he says, in other words, are you saying that he's obligated by the statute, 2014, the claim statute, write to his employer and say, look, I just want you to know that I have a bilateral hip problem attributable to my playing days.
And I think it.
And I'm not
it also-
asking for anything at this time because I don't have anything to ask for, but I'm making a claim. Is that what
I
his
think-
obligation is?
I think he does. And I think it also comes under the notice of injury statute 32-15-13, which the ALJ and CRB also found that he violated. Because not only do you have to put the
Well-
notice in writing, but you have to identify, it specifically says in 1513B, the nature of the injury. So only when the employer
Under
gets
Safeway,
notified.
though, under Safeway, we've held, adopting the CRB's view, we've held that the 30-day notice statute does not apply to a claim for medical services. So the fact that he didn't give notice is not necessary. Now, it may be dispositive for other reasons, having to do with the triggering of the statute of limitations, but we're going to put that aside for the present time. He didn't, I mean, the fact that he didn't give notice earlier that he had this injury doesn't seem to bar his claim.
Well, maybe we go back to the Moore case where they look at the unfair prejudice to the employer. I mean, when you don't give notice of a medical condition, the employer can't investigate it. We can't go get doctors. We can't care for the injured worker. I mean, there's huge prejudice to the employer in a situation like this where claimant waits 34 years. I mean, that's what we're looking at. This is outrageous. It's 34 years he waited from 1984 to 2018 or 2019 to put his employer on notice that something he knew in 2014 that he knew in his mind and he was testifying to, that his hips were caused from playing football. And the judge said, that's enough. When you know it's caused by football, you have to pick up the phone, you need to notify the employer, you need to put it in writing, you need to comply with the statute. You need to identify the nature of the injury. If you're alleging that there's hip injury, I mean, prior to that, the employer, he's no longer working for the employer. He's out on his own. He's doing his own thing. The employer has no idea he has hip problems. It's not in the 1984 records. The word hip is maybe mentioned 1 or 2 times. There's 54 medical appointments in 1984 when he only has groin problems. So the employer first learns of this in 2018, and the employer's prejudice, because had we known in 2015, had we known in 1984 that there'd be hip injury claims, we could have provided medical care. We could have provided treatment. And I think it's important in this case to recognize this case is unique. because the Washington Redskins provide free medical care to all their players. So the issue of providing medical care does not trigger workers' compensation. If you got a cold, it's free. You got tonsils that need to be taken out, it's free. It's in the record. The Washington football team provides free health care to its employees for whatever they have. And Judge Glickman, I think when you look at the Howard University case, you'll see that the Howard University case involved a medical doctor resident who had a stroke, and she has the stroke at work. She's treated by the doctors at the hospital, and the DC Court of Appeals correctly ruled that notice to the doctors is not notice to the employer. There has to be notice to the employer so that the employer can take those steps and that the employer is not unfairly prejudiced, as the employer was in the Moore case, unfairly prejudiced by claimant settling out and attempting to double dip. I think you're dealing with the same prejudice issues. And I think the court is correct in looking at and following and given deference to the Compensation Review Board. You have highly skilled workers' compensation judges that have spent decades looking at these very issues, looking at the notice, looking at what is a timely claim, and they make the call. This claim works, this one doesn't. This claim that we're here for today is 34 years late. We have to have some line by the court. We have to have a one-year statute of limitations that you file the claim when you know that the work caused that injury. And
Even if you're seeking, and just to be sure I understand your position, even if you are not seeking any benefits.
Correct. There has to be notice. I mean, otherwise the employer, how are we going to know? How is the employer going to know that this person that no longer works for us
Oh, I
is having hip
appreciate
problems?
the problem.
I mean, it's huge, and the prejudice is overwhelming. And to come back 34 years later and say, now, I want my hips replaced. Maybe the employer could have intervened in 2015. Maybe there's other medical care we could have provided.
I think the problem, counsel, is the most natural place to read a statute of limitations in a case like this would be 1513. I mean, that's the statute that provides when you need to provide notice of injury or death. And 1514 is just about the time in which you need to file a claim and when you file claims. I mean, that's the title of the statute. And it's at least a little bit odd to say, well, if you're injured and you might later have a claim, you have to provide us notice of that, even if you don't have a claim to file now. That having foreclosed 1513 in Safeway stores, it's a little bit weird to read the statute of limitations in 1514 as applicable absent a claim. I mean, it might be that we got Safeway stores wrong. I mean, you make a compelling policy point. It's just you would think that notice requirement that you're currently asking for would most naturally fit under 1513, and you're asking us, having said it doesn't fit there, to read it into 1514. And that is a little bit strained if there's no attendant claim to it.
And I think part of what the court's rationale in the Safeway case was, in that case, the employer knew that the claimant had a broken finger or problems with her finger. I mean, the employer's on notice. And that's why the court says, look, they didn't file the form, but you're on notice. And that's actually in the CRB decisions. So I think that's important, because in that case, they are on notice. And in the end, they're looking at a finger. It's a minor sort of injury. And the court at the end of that decision actually applies a but-for test and says, but for working for the employer, you never would have injured your finger. Well, that's entirely different in this case, because but for being a football player, he's still going to have the hip injuries. I mean, the medical shows that hip replacements and arthritic hips are in the general population. Has nothing to do with playing football. There's no indication that, I mean, I think you go, even in an auto accident case, you go back to the records at the time and say, what are the records? What are the indications of a hip injury? And it's not there. So are we going to let claimants' attorneys come in 34 years later and say, I know it wasn't in the record and there's not medical records to support a hip injury, but now 34 years later, I'm going to go get one medical opinion and say that this is all related to work, and I'm going to, within a year, file a new claim. And I think that's
I take your
disingenuous.
point. I take your point. Let us hear from counsel for the other intervener. Ms. Taroki, if I pronounced that correctly.
Yes, may it please the court, Your Honor, Cheryl Tarachi on behalf of the intervener Pro Football and their subsequent insured Great Divide. I want to come back to Judge Deal's question because I feel like it perhaps could be illuminated a little bit easier from my experience handling workers' compensation. And I apologize, I'm losing my voice from a post-COVID issue. So if you cannot hear me, please send a signal. It is not a technical error, it's my voice. So Judge Deal, you asked, is filing a claim just filing a claim, or is it filing a claim asking for benefits? And so we have to understand there's a reason why there are two separate statutory sections, one dealing with notice and one dealing with this limitation provisions of filing a claim. And there is a specific form from the Department of Employment Services in conjunction with filing a claim under 1514. And the top of that form says notice of employee's claim. And the information on that form is the who, what, when, where. What happened? When were you injured? Why is it related to work? What is the nature of your injury? And it is essentially what counsel was trying to say, which is bilateral hip. So for instance, I was in practice, I was hit by someone, I injured my knee. There is no claim for benefits, so to speak, or request for hearing in conjunction with that specific form, which is the claim filing, which unfortunately is also called a notice. The words notice and compensation, I will submit, are unnecessarily complicated and confusing.
Can you tell me where I'd find, do we have one of those in the record that you can point me to?
I don't believe it's in the record, but if you go to the DES website and click on the forms, it is Form 7 and Form 7A. And I can try to pull those up or give you the website.
This was something we were wondering about, frankly, in my
Yes.
chambers. We couldn't find the form.
It is on the DES website, and perhaps one of my counsel can pull up the exact address, but I want to eliminate sort of that is step one. So that starts the procedural process. So a complaint in a traditional litigation, so to speak. And so thereafter, if there is a dispute, that triggers a course of events. It triggers the employer to respond to the claim, what they're accepting, what they're denying, what they're investigating. It triggers responses as to whether there are benefits being paid. And then it triggers the hearing process should the claimant or the employer wish to file for a hearing or for claimant to seek specific benefits, an application for a conference. So to answer your question, the filing of a claim is filing of a claim to put everyone, for lack of a better word, on notice, but to say, I believe I have this injury and it is related to my employment. And here is what I'm alleging transpired, so that everyone has the information in real time to then deal with that.
I mean, it's interesting, and that might be, the pervasive practice, and maybe that's the right way to read the statute, but it's a little hard to reconcile with the language of 1514, which says, it's talking about filing a claim, therefore relating back to the right to compensation for disability or death under this chapter. I don't know. I don't feel like overturning every apple cart I see. It's just not so clear to me that is reconcilable with 1514A.
Well, I want to illuminate also the definition of compensation, which is also what's underlying the confusion and how all of this is interplaying together. And so Mr. Boscola was saying, talking about overturning Safeway. Safeway is a notice case. It is a 1513 case only. 1514 is not even mentioned in the Safeway decision. So you can decide 1514 without interfering with Safeway and
Well,
the finding.
let me ask you a question about that, if I may. I think this may be, in a way, the central question. How do you reconcile giving compensation in section 1514, in effect, a different definition from the definition given to compensation in 1513?
So the court in Moore has rejected the approach of adopting that narrow construction or definition of the word compensation. And they have said that the definition of compensation is context specific, meaning that it can mean different things in different areas of the act. And that just as they applied the definition of compensation to the particular statute section at issue in Moore, they explained that adopting this narrow approach would produce illogical and inconsistent results. And befuddle the intent of the statutory provision. And the same thing applies here, is that if you apply that narrow construction that compensation does not mean medical benefits, then what's the point of 1514 and what's the point of the statute of limitations? Because it would essentially render the statute of limitations useless. It would create this unlimited window where a claimant could always come back and file for medical benefits, where the employer has no knowledge or ability to defend or to investigate. So in this instance, 35 years later, the claimant comes and says, hey, by the way, I hurt my knee 30 some years ago and now I want treatment. There's no, then there's no application of 1514 and no statute of limitations, which I think statute of limitations are widely understood to be in play in litigation for a reason. And so,
well, of course, does it make a difference that the statute in effect, and this is true of 1513 as well, have a sort of a tolling period, which is the statute doesn't begin to run until the employee has reason to believe that a condition is attributable to something that happened at work. And that can be a long period of time in the case of certain types of injuries.
And that's correct, Judge Lisbon. And it puts the employer then at the same level with the same information as the same time as the claimant. So it's giving the claimant that understanding and sort of that space for what Mr. Buscolo is terming a latent injury or things that transpire down the road, or they simply did not know that this pain or complaint or problem they're having is related to their employment. But when they do know, they are obligated by virtue of the limitations provision to tell their employer, by the way, I have this condition and I believe it's related to my employment, so that the employer is then in the same position at a contemporaneous point in time to do their investigation. And
so is that true where in this situation, according to Mr. Bosco, if I understand correctly, Mr. Anderson knew for some period of time that he had a hip problem that was hip pain, hip discomfort, whatever, that was attributable to his football playing, but he had no claim for benefits to make with respect to that claim for a number of years. In other words, he wasn't seeking anything because he was already getting disability, I guess, from the employer because of his other conditions. And Mr. Bosco, as I understood it, said that really it was not until 2018 that he had a claim for benefits to make with respect to his hips, and therefore he did not have to make that claim earlier than 2018. And he had a year from when he was presumably told in 2018. That's what I understand the nub of what Mr. Bosco was arguing earlier to be. And if I understand you and Mr. Numrick correctly, your position is that even before he has a claim for any particular benefits to make, if he knows that he has a condition, an injured condition, a damaged condition, attributable to something that happened at work, that's when, that earlier time period is when the time to make a claim starts to run. And the question, I guess, is which of those two interpretations best meets the statutory language? The regulations define a claim as an application for benefits made by an injured employee, including medical benefits. But until this argument, I don't think I have focused on the notion that Mr. Anderson and I don't think this was an argument Mr. Anderson actually made below, at least I'm not aware of it, but that Mr. Anderson had no, quote, claim to make until 2018. Of course, he did make a claim to the NFL in 2014.
I have two comments. So one, and I can circle back on, but one is that when the claimant knows, the employer has a right to know as well within that reasonable time period. And so if we're going to use that 2014 date of Mr. Anderson then knew that he was having a problem. So he has pain or has some kind of problem with his hip, and he has knowledge at that point that it is related to his employment. The employer is entitled, or else is in a very unfair prejudice standpoint, without also having that same knowledge within a time period. To answer your second,
That as a policy matter, that sounds very sensible. But what statutory language do you rely on to require the notice to be made, or the claim, the claim to be made before it was here?
So I'm relying on this on the 1514 that we've talked about, but I think what you're getting to is the second part of your question that I had not yet answered, which is we're talking about a claim being this filing of I have an injury versus a claim for benefits. And in this case, Mr. Anderson requesting the surgery. And this is a unique situation because of the fact that he has other ways of getting medical treatment. But, this statutory construction applies to every individual seeking medical treatment. And so by saying to the employer, I have an injury, the next logical step is that you need medical treatment, or you need at least an evaluation by a physician. So there might not be a large surgery on the table. There are a lot of individuals who will get this medical treatment, or things will come up before it gets to the point that they say, I'm not paying for this, or I'm not aware of how this works or something. But when you have an injury, you're implicitly in need of medical care. I have a pain, there's something wrong with me, but I have knowledge that there's something different about my body, and I am relating it to the nature of my job. But I would argue that impliedly tells the employer, I may be seeking medical treatment. I have an injury. It allows the employer the ability to get an IME, to get a doctor, to have someone evaluate the claimant, to talk to the claimant at the time that he gets the knowledge as to what his knowledge is and what's going on. So even
Ms. Toroshi, can you help me with that? Because it seems like, we heard from Ms. Boscolo that Mr. Anderson's a UVA educated guy, and he's very smart. But what type of knowledge are we putting on people? It sounds like the standard you're saying is that, I played football as well, and if my shoulder starts hurting and I have an inkling of an idea that it could be related, then I need to go give notice to the last team I played for. And I didn't obviously play for an NFL team, but I'm about 6 inches too short for that. But we, are you saying that the standard is they have a remote suspicion it could be related and they need to give notice there? Or is it when a doctor tells them, okay, well, we're looking at your hips, this doesn't look natural, this looks like you taking a beating on a football field? Like, just when does that knowledge apply? And it sounds like you're setting a really high bar,
and
a really low bar, rather.
And Your Honor, I believe the case law is fairly clear. That is the claimant's actual knowledge, and his actual knowledge that he has an injury and that it's related to the employment. And usually that is by a doctor. So that is usually someone in a practical situation going to a doctor and saying, I'm having this condition. And the doctor saying you have this condition and it's related to your employment. That is typically how it arises. I do not believe the case law has said that the notice comes from a doctor, but I wanted to answer your practical question of, do I need to address every single pain that I have that might ever be related to any job I've ever done? And that is not the bar. But in this particular case, Mr. Anderson, at the very least, has acknowledged that in 2014, he had knowledge that he had this bilateral hip condition and it was related to his employment
I'm wondering whether we've been focusing in a way on the wrong statute. We've been focusing on the claim statute, section 1514. But now I'm wondering whether we really should be focusing on 1513. 1513 requires notice of any injury in respect of which compensation is payable shall to be given within 30 days after the employee is aware of the relationship between the injury and the employment. Now, it seems to me that while we said in Safeway that a claim for medical benefits is not subject to the 30 days, that doesn't mean to the 30-day requirement of 1513. That doesn't necessarily mean that Mr. Anderson wasn't required to give notice within of his hip injury within 30 days after he became aware of its relationship to his employment, because a hip injury is the kind of thing for which, under the Workers' Compensation Act, compensation is payable. He may not seek such compensation. He may be getting such total disability benefits from some other source that he doesn't need it. But it does seem to, now I'm thinking that perhaps we should be thinking about this as a case in which Mr. Anderson failed to give notice within 30 days. And if I understand 1530, was it 32? 1532 correctly, that failure to give notice means that the 1 year statute of limitation, well, let's see, where does that get us, I guess is what I should say, if we rely simply on his failure to give notice of the injury. Under Safeway, he can still belatedly seek medical. So does that mean we are still inevitably going back to 1514?
Your Honor, I would submit that he has not given timely notice under 1513, nor has he timely filed a claim under 1514. And what I would explain to Your Honor is my understanding of how those then kind of work together. This is my interpretation that this was a balancing of the interests of the claimant and the interest of the employer and the potential prejudice. So if you look at 1513 and the Safeway decision, the court has determined that when the claimant does not give timely notice, the claim for wage loss benefits is barred, but he is still entitled to medical benefits. Then you bump up against 1514, which is in 1 year. And if you have not then made a claim within 1 year, there are no benefits to be afforded to the claimant, either wage loss or medical.
The regulations seem to support that, but that gets us into this conundrum that Mr. Boscolo has raised in my mind. Well, what was his claim for benefits?
It's a specific form, and it says it's a notice to the employer that says, in 2014, I know that I have this bilateral hip condition and it is due to my employment. That is the claim that we are talking about that triggers the 1514. In the same way that we talk about, I'm filing a claim to preserve limitations. That's what we're talking about here. We're talking about filing the document with the Office of Workers' Compensation, giving the employer the information as to what you're alleging, which is I have a bilateral hip condition, an injury related to my employment. And that is where the clock is. That is what 1514 means. And I would submit that Mr. Anderson didn't either. But at the very least,
it's funny, it treats 1514 as simply duplicating what should have been done under 1513.
And that's why I believe it's a balancing of the interests. And so part of it, I believe, is the prejudice that is borne on the employer in the different types of claims. And that comes down to the practical day-to-day of medical only, what we call medical only versus wage loss claims. And so at times they are treated differently due to the time sensitivity, due to claims handling decisions. And generally there's little prejudice to an employer by a delayed notice of 30, 60, 90 days for medical treatment, because the employer can get an IME, they can get a doctor in there to look at, they can get a utilization review to determine if the treatment the claimant has already gotten is reasonable and necessary. So that period of notice that we're talking about as it relates to getting medical treatment, perhaps that prejudice is less. But the interest that you're then talking about as you're getting out to a year, that gets more significant. So now we're a year past when the claimant either knew or in most cases was injured. And so the employer's ability to get contemporaneous evaluations of the claimant's condition, what's happened in that intervening year. And to be able to kind of go back and look at the claimant's condition is different, but it's also significantly different when you're talking about wage loss benefits. And that is why I say it's a balancing of the interests, because you cannot go back in time and defend a claim for wage loss benefits, because those decisions and that information have to be made in a time-sensitive, contemporaneous time period. So I'm sorry, Your Honors. So at the time that, let's say the claimant is injured and is missing time from work, the employer needs to know that that missed time from work is one, happening, and two, is happening because of an injury. So they can evaluate the claimant's functional limitations at that point in time and make any decisions such as, could the employer accommodate restrictions? Is light duty available? Are there things that they could do to mitigate the wage loss?
I think we understand the policy, the importance of that policy. Well, listen, let me thank you.
Thank you, Your Honor.
Let us hear from Mr. Bosco. Mr. Bosco, we'll give you a couple minutes.
Your Honor, this is
Use
exactly
your
what
words carefully, because it's only going to be a couple minutes.
This is exactly what I was afraid was going to happen. Mr. Anderson has filed 3 claims. There is no record on any of those claims. This whole conversation we had is very interesting and academic, but he's filed a claim for July 26th, 84, September 10th of 84, and May 9th of 2018. There is no finding of fact in the record on any of those claims. We're having this esoteric conversation. That's not what ALJs do. This is an advisory decision, she wrote, number one. Number two, the whole conversation led by co-counsel for Pro Football Inc. is a little offensive, because the suggestion that there's some way that Mr. Anderson could get this care other than waiting 5 years now. If Washington was providing this for free, or if he could get it some other way, I wouldn't be here bending your ear. That's just not relevant or fair. But more importantly, what they suggested he do is exactly what he did. When he had notice that he had a hip injury back in 1984 to both hips, he filed claims. He didn't need any medical care until 2018. When he became aware he needed medical care in 2018, he filed another claim for compensation. He's got claims on file.
The premise of your argument seems to be that he gave notice of a hip
Of
injury in
But he-
2004.
If
I think you have to operate from the assumption that we're not persuaded that he gave notice of a hip injury in
Well,
2004.
Your Honor, that would be fine, except there's no evidence in the record to support that. And there are x-rays and diagnoses of hip conditions in the Redskins records in 1984. That's a fact finding that maybe could have been made by the ALJ, but since they didn't reach the presumption of compensability, and what you just said, Your Honor, that would require an application of the presumption to conclude he did not have a hip injury in 1984. That wasn't done here. And this whole conversation we have is
No,
a matter.
I didn't say he didn't have a hip injury in 1984. I'm saying he didn't give notice.
He filed a claim and reported it to the trainer. It's uncontested that he told Bubba Tyer about his problems with both hips. The only way they attempted to rebut that was by saying, well, that's not credible. Well, in Murray, this court said you can't rebut the presumption by saying the claimant's not credible. They got to produce some evidence, and they produced nothing, no evidence. But again, This issue, this whole conversation we've had is a matter of settled law in the District of Columbia. Because this issue of when, so this is about what is an injury under the law. In an accumulative trauma case, which this is, going back to Railco in 1989, this jurisdiction has adopted the manifestation law rule, not the notice rule. And the director in Franklin about 20 years ago said manifestation is the earliest of when the injured worker seeks medical care for the cumulative traumatic condition or becomes disabled by the cumulative traumatic condition. Disability under the statute is defined as wage loss caused by injury. Mr. Anderson has never been disabled by his hip injury. He never required medical care until 2018. He never had an injury to report. But once again, you should send this back and tell the ALJ to make findings on the claims that Mr. Anderson made. Put him in context of his claims, not in when she thinks he should have made the claim. She didn't pick any of the claim dates. Her order is based on 2014. The claims are filed in 1984 and claims are filed in 2018. Notices of injury are filed in 1984 and 2018. 2014 under the manifestation rule is irrelevant, and it's led us down this rabbit hole, and no one can say that there's an adequate record to support the finding that the 2018 claim or the two 1984 claims are borrowed by either notice or limitations. And the reason the ALJ didn't respond to those is because they're not. The ALJ is persuaded by the public policy, but that's tough. You got to apply the law as it exists. This is social legislation to protect injured workers and to not shift the responsibility from Pro Football Inc. to the taxpayers. This case has to go back for findings on Mr. Anderson's claims, not on some wishful claim that the ALJ formulated. I'm sorry, Your Honor. I don't think that any of the stuff we talked about looks at this case on this record. That's really all I have to say.
Okay, I think we have your arguments. Counsel, thank you both thank all three of you very much. The case is submitted and you may log off. We call the third case on the calendar, Longate Associates versus DeVar Hallow and Longate Associates versus Ochoa, two consolidated appeals. Counsel, you may proceed. Mr. Moore, I think.
Good afternoon, Your Honor. Apologize. I think we're listening to other arguments that appear to not be for the same panel, and we're confused why. That was the source of my confusion. I was waiting for that argument to end. All right, I'll begin. Thank you for your time today. Actually, may I begin with a question about how we should proceed? We're here on appeals of two matters, I understand it. The appellees in one of the cases are the De Carvalhos, and in the other case, it is Ms. Ochoa and I believe Ms. Nunez, or I'm sorry, Mr. Nunez, I apologize. And there are many of the arguments are similar, but not all of them are exactly similar. So would you just like me to address?
Well, I think you should start out by addressing what you think is your most important argument to make. Many of the arguments, as you say, do overlap in the two cases. There are a few areas of difference.
I will proceed in the fashion that I had intended, Your Honor. Again, I believe that the judges in both of the opinions that were rendered on summary judgment in each of the two cases were incorrect. All of their findings were incorrect, as Longate, the receiver and appellant, Longate, who sued in the name of the cooperative, is authorized under Judge Rigsby's May 2nd, 2019 order, Rule 3-IB2A of the landlord-tenant branch's rules of the Superior Court, Civil Division of the Superior Court, the Randolph Towers Cooperative Inc. bylaws, the occupancy agreement signed by both appellees, as well as the contributor participant agreement entered into by appellees to bring this action. Additionally, this action is neither barred by the doctrine of collateral estoppel, for reasons I will explain, nor is it barred by the statute of limitations, 3-year statute of limitations for breach of contract, for additional reasons that I will explain. Starting with Judge Rigsby's May 2nd, 2019 order in a case between Longgate and the cooperative, Judge Rigsby entered an order appointing Longgate as receiver, and in that order, he gave a broad authority to Longgate to proceed to manage the affairs of the cooperative. And I bring this up because it's in stark contrast with the statutory receiverships that appellees and the judges in the trial court looked to as guidance, including the Jeter decision. The powers here are far broader than statutorily appointed receivers. Longgate took over all functions of the cooperative pursuant to that order, was given possession of all books and records, accounts, collateral, and monies, given authority to hire a property manager, authorized to repair, renovate, and alter property, authorized to raise carrying charges in excess of 10%, which would be contrary to the bylaws of the cooperative, and was authorized to settle or compromise all existing bills and claims and to borrow. It was additionally added as an insured on the cooperative's policy. So these powers are very broad, but let's get to specifically the powers that the receiver has to pursue a tenant at sufferance action. The order gave Longgate the authority to fully litigate matters as it sees fit. It enabled Longgate to engage counsel for the purpose of bringing legal actions in the landlord-tenant branch of the Superior Court. That order did not limit the receiver to any particular type of action in the landlord-tenant court. It wasn't limited to non-payment of rent actions. It wasn't limited to what I would call a holdover action. And additionally,
And bringing certain types of actions, such as the one here, do rules of civil procedure, in effect, require the receiver to bring in the co-op as a co-plaintiff if necessary?
Rule 3I, I hope you were finished. Rule 3I does not require a receiver that is 3I, I believe it's subsection C. I have the rule right in front of me. Requires only under subsection, I believe, B2A. All other subsection A of 3I deals with statutorily appointed receivers. I think we can agree that the receivership here does not apply to that. Subsection B, I think it's B2A, requires that all other receivers produce a copy of the order that gives them the powers to proceed as a receiver, and also requires them to provide a statement as to why they are not joining what normally would be the landlord, but here would be the cooperative.
Was a statement given? Was such a statement provided?
It was provided supplementally to the complaint. It was not attached to the original complaint. If this case is remanded and or if the court grants the appeal and overturns the verdict, we would ask that the court allow the appellant to amend the complaint to provide that statement. That is normally what is.
I don't want to be too critical here, but it sounds to me like in the first 5 minutes of your argument, you're citing rules and raising issues and claims that I don't remember, maybe I'm mistaken, I don't remember seeing in the briefing.
They are in, all of this is in the briefing. I've cited to the order appointing the receiver, from which it gets its authority. The reason why I'm referring to Rule 3I of the procedural rules and subsequently may refer to Jeter is that at least the judge in the De Carvalho case was persuaded by dicta in the Jeter case to say that the receiver did not have authority under Jeter to proceed with these filings.
Well, I understand you're relying on the order in this case. Was the co-op an indispensable party to this litigation in the De Carvalho or the Ochoa?
No, I don't believe they're an indispensable party because, one, the receiver has all of the records, but more importantly, the reason why the receiver
Does the co-op have no interest whatsoever in the outcome of this proceeding?
I do not believe it. The co-op's interest should be coterminous with the receiver. If the court most likely, assuredly, has reviewed the bylaws, the occupancy agreement, and all documents related to the formation of the cooperative and the transition from a tenant association, the entire purpose of the cooperative was to convert to a condominium association and for the former tenants to become members of the cooperative and to purchase their units. And if they did not purchase their units, to vacate. So the continued occupancy by the De Carvalhos and Ochoa and Nunez is antithetical to the very purpose. We're now, I think this began in 2006, we're now some 15, 16 years later, and the purpose was to purchase and or get out. And a few members, including the appellees here, have failed to do so. The cooperative, as you've seen from some of the exhibits, is much more expensive to run than a condominium association. Most of the units have been converted to have become, or the owners of those units have become members of the condominium association and are contributing to that condominium association. It's much cheaper to run. That's what the cooperative's own attorney said in 2009. It's way too expensive to run a cooperative. So yes, I do think the cooperative's interests are aligned. I do believe, however, that because the cooperative was non-functioning and is limited to very few members who benefit from continuing to have occupancy of their units at what previously was a reduced occupancy rate, that they may not, those individual members may not want to see this litigation go through because it's against their individual interests. But the cooperative's purpose as a whole was not to exist for 16 years. It's just a horrible way to run a business, as acknowledged by its attorneys. So no, for several reasons, I don't think the cooperative is a necessary party. But even if this court disagrees and or believes that the trial court should investigate further, the remedy is not dismissal of the case. The remedy is to amend the case under Jeter, which appellees rely on significantly, would be amend the case to stay the case to allow the cooperative to be added as a party for whatever value that might bring.
Counsel, I haven't heard you mention this yet, but it appears to me from the record we have a unique scenario where the same judge that issued the receivership order is also the judge in the Ochoa and Nunez case. And it was cited in the briefing that the judge dismissed the standing issue entirely. Is there should we be giving that any particular weight not dismiss on your client, but did not grant a motion to dismiss on this standing and authority issue.
That was something that I believe should be given some weight, and I was going to mention a little bit later that Judge Rigsby did not address those issues raised by Ms. Ochoa and Mr. Nunez, and did not find that his order was lacking and failed to give the receiver the power necessary to file a tenant at sufferance action. So I do believe it is noteworthy. I guess if you want to be a contrarian view, just to be honest, would be that maybe Judge Rigsby felt a little self-conscious about ruling on his own order, but I think the more basic understanding would be that he disagreed with Ms. Ochoa and Mr. Nunez and felt that his order was sufficient. And I believe it's clearly sufficient. It says it gives the receiver the power to file all actions resulting from a breach of the occupancy agreement. And that's what this is. Even though it's called a tenant at sufferance action, it results from a breach of the occupancy agreement.
Well, is the failure to purchase a unit within the time period a breach, a violation of the occupancy agreement, or rather, is it essentially just, does it essentially just place the occupants in, assuming that valid offers were made to them? Big issue and dispute. But if valid offers were made to them and they chose not to accept them, doesn't that just make them holdover tenants?
No, Your Honor, not at all, because they've never been tenants. They started as tenants.
I don't know that there's a difference between an occupant and a tenant.
Absolutely, there's a difference between an occupant and a tenant. A tenant is imbued with more rights, automatic renewals of lease terms, even if they're month-to-month tenants and can only be evicted for cause. They are not tenants.
So why are they not tenants? They have an occupancy agreement that allows them to occupy the apartments, presumably so long as they pay their rent. And until a certain point. Why aren't they tenants within the meaning of the Landlord and Tenant Act?
And renews year to year until it hits one of those certain points.
Subject to the terms of the occupancy agreement. This was carefully set up. They started out as tenants. All of these tenants willingly agreed, at least the majority or vast majority, I don't recall what the numbers, whether it was 2/3, 3/4, to convert to a condominium association, what those voting numbers were required to be. But everyone started out as tenants and willingly agreed to transition from a cooperative. And as a cooperative, you're not tenants, you're essentially, you're part owners. And that's what the membership agreement is for. The bylaws addresses the ownership interest. The occupancy agreement addresses the right to occupy. So you're not a tenant, you're an owner of the cooperative, of a dying or dead cooperative. And that's your interest. You can't be both an owner and a tenant. So if you are a member and signed an occupancy agreement, you are an occupant and you are allowed to continue to reside in the premises if you comply with the terms of the bylaws and the occupancy agreement. Importantly, one of them being the very purpose of the cooperative, which was to transition everybody either out of the buildings or into becoming condominium owners and members of the condominium association.
And you said that, you know, the bylaws really govern the ownership interest. The occupancy agreement really governs the occupancy rights. I have a question on that topic, and it's in Article 4C2 of the bylaws. What it says is each member, this is the bylaws, not the occupancy agreement. Each member is entitled to occupy an apartment solely by reason of his or her ownership of a membership interest in the cooperative. And if you take that in conjunction with, I think it's 5G, sorry if I'm scrolling through my document here, but the part that requires a board vote to kick somebody, discharge somebody of their membership. Reading those two in conjunction, it seems to me like in order to lose your occupancy interest in an apartment, you need to be divested as a member by the board, by a board vote. What's your response to that?
I disagree wholeheartedly. I believe that the occupancy agreement is an agreement that stands on its own, and I was actually going to bring up the section that you cited, I think Roman numeral 4C, Romanet number 2.
Right.
And that says that that the interest can only be in their occupancy is in accordance with the occupancy agreement. So it ties into the importance of the occupancy agreement for their continued occupancy in the units. Occupancy and membership are two different interests, and definitely trying to find my notes, but you have the right section.
Help me understand as you go forward too. If I'm a member, but I have no occupancy, what interest do I have left?
Well, what interest you have left is presumptively any financial interest in the cooperative, whatever might be remaining. I don't know what might be remaining because interest on loans have continued to accrue, but after all those loans are paid off and any other liens, I believe the condominium association that was created has a judgment lien against the cooperative. So there may not be any remaining financial interest, but at the time these bylaws were created, there was definitely a dichotomy set up between the occupancy agreement and the membership interest, and how somebody could be compensated for their membership interest is specified in these bylaws if they choose to terminate their membership and or occupancy. So the bylaws definitely speak to a financial interest. Again, what it is now may be fleeting if non-existent, but that is part of the issue here. This cooperative was not intended to last for 17 years. It was intended to last for a year or two. And I mean, for whatever reason, these occupants or the appellees here were unable to complete their purchase.
Well, let's talk about that because that seems to be the heart of the issue here. The question is whether the offers to, well, I say this with some hesitation because I know so little of the background here that I wonder if I'm right in what I'm saying. But I gather that the $64,000 question is whether the purchase offers made by the co-op to the occupants, to the members here, were or were not compliant with the contractual provisions requiring such offers to be made at a price at a price that was estimated and a price that was intended to be required to be below market value. The judges below seem to have thought, in granting summary judgment to the occupants, that the provision that there was no breach of the occupancy agreement because those offers were non-compliant. It sounds to me, from what little I've been able to glean, that this is a matter of a genuine factual dispute and not susceptible to summary judgment. Do you disagree?
I do not disagree with your last point that summary judgment should not have been granted without more information. I do believe, though, that we have proven that a compliant offer was given. But absolutely, the appellees.
Well, it's hard
focus-
because nothing in the briefs answers that question for me.
Well, we did, I think in both our briefs, we did say at a minimum, this should be remanded for summary
Yes, you
judgment.
did say that, but
For further discussion or further,
other than saying that those numbers were intended to be estimates, there's no real discussion in your brief about whether the offers that were made were
compliant.
in accordance with the contracts or not.
Right. Okay. So I believe one letter that is part of this focus is Mr. Schumann's, Jonathan Schumann's 2016 letter that each of these occupants received. And in that letter, he has a higher price, not substantially higher. I think in one instance, $30,000 higher. That's substantial for some purposes, certainly.
Each of them are around 30% higher.
30%? I apologize. And no, there was no focus on how Mr. Schumann came up with those numbers. But what at least brings into a question for the trier of fact, which would negate the summary judgment ruling, suggesting that the summary judgment was too soon, is all of the conditional language in the contribution agreement, which is one page, but all the language, the preceding 4 or 5 pages describing the program is incorporated into the one-page contribution contributor participant agreement. In that, it's full of language that it's the discount price will depend on the size of the unit, location, the number of units required to be sold to the general public to allow these discount prices to go through. More importantly, though, you can see estimate is all over this document, the contributor participant agreement, idea, estimate, all that language, how anybody could rely on that number, I'm not sure. But even if.
But counsel, you would agree that they could rely on some sort of analysis of all of those factors that were incorporated, as you just said, that there should be something, and you're saying that there's nothing on the Schumann record, which I apologize for giving you a compound question that perhaps one of the trial judges would have sustained an objection to me on, but also what else is there for there to be discovered? Because it looks like we went through full discovery and opposing counsel has made a strong point of they're just, and perhaps to go with your point of how the co-op is essentially defunct or wasn't operating, there's just not meeting minutes and other discoverable evidence that would contribute to this. And to add the third part of my compound question, I'm wondering why it wouldn't just be better for your client to go do the analysis itself and send out a new offer and put them back on the spot.
Well, informally, to answer your question, informally in settlement negotiations, I believe that was done, but not as this procedure. Let me answer the first part of your triumvirate question by stating that an important section, going back to the occupancy agreement, section 15.1 of the occupancy agreement states that the member and cooperative both agree that the agreement and all of the members' rights are subject to and subordinate to all liens, mortgages, and taxes for the property. That the initial driver in the contributor participant agreement, initial drivers beyond the estimates, the vague language, conditional language, the initial drivers were the construction loan necessary to bring an apartment building into a viable condominium building where you could sell the units and pass inspection. So that was a hesitation and why there are estimates. But you have to look at section 15.1 where the cooperative is saying, we are taking out loans for these purposes, and your rights under this contributor participant agreement are subject to those loans. And if we went back to the trial court, we could likely establish a basis for either Mr. Schumann's numbers, or different, perhaps even higher numbers for a purchase price. I mean, these individuals' rights are, as you can see, are clearly not in a vacuum. They're subject to so many other factors. You can't just say, give me the price at the 2006 price, estimated price, 16 years later, and ignore all of the construction loans, all of the refinancing. I believe once the cooperative purchased the property, construction loans converted to permanent financing, which is likely what we're dealing here with several lenders later, purchasers of that loan later. We're dealing with that debt, and that debt is what, pursuant to 15.1 of the occupancy agreement, has to be accounted for first before anybody has a continued right to purchase at an insider price. So yes.
Were all these factors put in the record before the judge at the time summary judgment was sought?
Yes, I believe so. Well, 15.1, the occupancy
Well,
agreement.
I understand the agreement was, but I mean the specific factors that justified the prices that were quoted to.
Oh, no, Your Honor, no.
Well, how is the judge supposed to deny summary judgment if you don't do that? And how are we supposed, if it's not in the record, how are we supposed to overturn the summary judgment ruling?
Well, he could have left the parties as they were and not grant summary judgment for either side, because the other side, the appellees here, did not establish that the insider estimated price in 2006 was intended to continue on some 15 years later. So
if I remember, I mean, correct me if I'm wrong, but you know, reading from the court's order, you know, it said, you know, the $149,000 in the occupancy agreement was the purchase price, period. And I understood the dispute between the parties, and maybe this is a better question for appellee, was whether or not that was set in stone, in which case I think reading the occupancy agreement, it quite clearly isn't. Or if it's not set in stone, I don't see the trial court saying you didn't justify the bump up. I see it as just saying there could be no bump up. What was in the occupancy agreement, that's all there was. And was that the dispute between the parties, or was there also a challenge that the bump up was not adequately justified under the agreement?
I believe you're correct, the primary dispute, and perhaps the sole dispute, was the occupants, the appellees here, believe they are entitled to some 15 to 20 years later continue to purchase at that initial estimated insider price, which would be a great bargain if you could get it. But that was the court's reasoning that we had no basis for showing that the price could be any different than that. And I believe the documents and the provisions we've already gone through are replete with examples how it's estimated and examples of how or conditions stated by the cooperative as to how and why the prices would go up for the insider purchase price. And something that the cooperative's attorney warned about in 2009.
I know we've pushed you far over time, and I suspect that your time may be coming to a close here. So along those lines, you know, I'd like if you could address for us what you said you were intending to at the outset. It appears the judges also relied on the ruling in the earlier case that had been brought years before your client was the receiver, and this collateral estoppel point. And so why is that invalid?
The biggest difference here is that these are two separate actions, and you have to look at the actual complaint forms filed in each case. The Sunupe case, Mr. Schuman, in his checked off the box under page 2, the top of page 2, section, what is 3B. There are several boxes when you get a chance to look at it, at this form complaint, using the court's form of what a practitioner and/or landlord acting on their own behalf has to fill in. Mr. Schuman chose to state, check the box, defendant is a terminated cooperative member holding over after expiration of a notice to quit pursuant to DC Code Section 42-3203. That in the current lawsuits, the plaintiff checked the last box, other reason, and there's a line to explain fully the reason. And it stated, defendant is a tenant at sufferance who failed to vacate after receipt of notice to quit. So the Sinupe case more properly dealt with Roman numeral 5 of the bylaws, which required a vote to terminate the membership. As you've probably noted from our arguments in the documents itself, Section 22.2 speaks only to termination of the occupancy agreement. And we've already discussed the difference between occupancy rights and membership rights.
The council, isn't Sinupe also where a court first found that point about the purchase price being guaranteed either in the bylaws or the agreement?
They may have, but again, it's not the same cause of action, and I don't know how that can be binding on this cause of action, particularly because of the different under the fairness doctrine. The last element of defensive collateral estoppel to burden the receivership with the what the cooperative did or failed to do in any litigation. I'm not even sure the cooperative defended that summary judgment motion. It would be extremely unfair to the receiver here, particularly since they are different causes of action. And because, I mean, the cooperative didn't oppose the summary judgment motion and then certainly didn't appeal the summary judgment motion and that finding.
So the receiver steps into the shoes of the cooperative, right? And
Not
so-
according
ahead.
according to the appellees. The appellees say the receiver has no powers. So they
If we agree with you on standing, if we get to the merits, we will have assumed you have stepped into the shoes of the cooperative, right?
Correct.
Is the receiver like a bankruptcy trustee?
In a while since I've done bankruptcy work,
All right,
done a
well,
little.
no question.
It's probably closer, it's definitely closer to a bankruptcy trustee than, I don't think it's quite equivalent to a bankruptcy trustee because a bankruptcy trustee has incredible powers over all.
Describing the receiver's powers before seemed rather broad.
They are pretty, I think they're close, much closer to a bankruptcy trustee's powers than certainly a statutorily appointed receiver under Jeter and 3-I.
All right, let us hear from counsel for appellees. And
Okay,
I'll give you a
I
couple of
did not-
minutes in rebuttal.
One thing that did not get addressed and maybe on rebuttal is the statute of limitations issue. But you didn't have any questions about it, so maybe it's not important to address. I'll wait for rebuttal.
We'll see what you want to do on rebuttal. Ms. Christidis?
Thank you. Good afternoon, Your Honors. May it please the court. My name is Eleni Christidis. I'm an attorney with the Legal Aid Society of DC, and I represent appellees Roberto and Vania de Carvalho, Selena Ochoa, and Moises Nunez. Your Honors, Longgate failed to meet its burden at summary judgment, demonstrating that there was a proper termination of the members who are appellees here. Both Judge Higashi and Judge Rigsby independently arrived at the same conclusions. First, that there was no evidence of a proper termination of the members by the votes and meetings required by the bylaws. And second, that the final 30-day notice of right to purchase on which Longgate's entire claim hinges did not offer the members the right to purchase their units pursuant to the contributor participant agreement. These two grounds were the very same legal conclusions reached in a separate
matter brought by the cooperative against an allegedly terminated member, Mr. Sanupe. In that case, Judge Puigalugo did analyze both the bylaws and the occupancy agreement and arrived at the same legal conclusions, that termination of the memberships required votes and meetings of the board, and that the inconsistency between the price that was actually offered the member and the terms of the contributor participant agreement invalidated that notice and invalidated the subsequent eviction action.
I have to say it's a very strange conclusion to me that the discrepancy in price would invalidate the offer, given that it does seem quite clear that the numbers given in the agreement are estimates. So what's your defense of that?
The defense is that it was Longgate's burden to establish, because Longgate claims that it's offering the units for purchase pursuant to the contributor participant agreement. And when you look at that agreement, the agreement lays out what the prices are, what the insider prices are. And then there's no further basis by which a judge on summary judgment can determine the validity of the prices that were actually offered. There's no justification for those substantially higher prices. The factors that Mr. Moore was discussing earlier, there's no evidence in the record of any of those factors, and none of those factors were raised as a basis for denying summary judgment in either of these cases.
Well, counsel, the question came up when Mr. Moore was arguing, is this something that your side brought up below, that there was no justification? Or is this just you're solely relying on the finding that we're questioning you about now, that they didn't meet the price listed in the estimate listed in the piece and the different agreement in the bylaws?
It's a little bit of both. It's a combination of both, right? Because the way that Longgate can meet its burden to show that there's a valid offer under the contributor participant agreement is they can either say, we're going by the insider prices, or we've deviated and we have a basis on which we're justifying the deviation. And so they didn't put forth any evidence to substantiate the latter position, which seems to be their position now and has been. They didn't put forward any evidence to create a material dispute of fact.
Well, I guess I come at it from a slightly different perspective, which is if the dispute is whether or not the price is in the occupancy, and I don't know. I mean, I guess I'm going to kind of reiterate Judge Howard's question. If you can point me to something in the record, that would be great. If the dispute below was, well, are these prices set in stone? And your position was, yes, they cannot deviate from those. Then I don't know why appellants would try to justify bumping that up if the dispute was just about, well, can they or can't they? Can they or can't they bump up that price? That seems to be very much the question that the trial court was answering. The trial court seemed to say, as I read the order, no, they can't bump up the price, which seems to be contrary to the plain language of the occupancy agreement. But it might be that you said, well, even if they could, they haven't justified it. But I don't see the trial court grappling with that kind of argument. So maybe you could just explain to me whether it was made.
We didn't take such an extreme position at the trial court. We said, okay, if these prices can be adjusted, then they would have to be adjusted by some kind of amendment voted on by the membership, because these prices are in the bylaws. They are listed out as an exhibit that's attached and incorporated into the bylaws. So there would have to be some evidence of an amendment. There is no evidence of any vote of the membership, any meeting minutes saying that there was an amendment. So we don't know where Longgate is coming from, and we don't know where the cooperative was coming from in 2016 and saying, here, we're offering you your units for purchase under this agreement that you signed. We have no, basis to really give that credence.
I mean, I guess I understand the argument, although I'm tempted. My reaction is basically, well, it's all over these agreements that this is an estimated price. Property can change value over time, and there is a significant gap in time here. And so if your position was just, well, it would have to be a vote by the membership to change price, I might have a similar reaction. Well, it doesn't look like the price was ever set in stone. But if you're telling me, did you make an argument like, there's just, they could provide evidence independent of a separate board vote that this overage, that this bump up was justified, but they haven't. Was that kind of argument made?
Yes, I think so, because we were saying, okay, you're pointing to us to this agreement. We're looking at this agreement, and you just can't explain this bump up. You've offered no evidence, no probative admissible evidence to explain this bump up.
My reaction is no. There's been a gap in time. Anybody who's followed real estate in the District of Columbia, even casually, would tell you that in that, in over 5 to 10 years, things can bump up considerably. So again, I'm really kind of wondering what the state of play was in the arguments in the trial court, because if your client's argument was they couldn't do that without a board vote, well, then I don't see why they'd provide evidence that the 30% or so increase was justified if that wasn't really in dispute. The real dispute was, well, they can't do it without a board vote. And if that's, I'm repeating myself a little bit. I just don't know if I've heard a clear answer to my question yet, which is, were you making the second type of argument that no, you might not need a board vote, but they're missing evidence that they would need to justify this 30% bump, even if we don't need a board vote? Was that kind of argument made?
We were giving a plausible example of how Longate could have met its burden in showing the justification for the bump up. We're saying, okay, well, we understand that it says estimate in these agreements. This is how we think they might have been able to carry that burden. This is an example of the kind of proof they could have offered to justify this notice as a basis for terminating and, according to Longate's position, evicting these members. But they didn't offer anything like that, and they didn't offer anything like anything else. There's just nothing. I want to speak a little bit about
Do you dispute, if I may ask, do you dispute that? I mean, you seem to be arguing that that any change in the price, whatever the explanation for it, has to be a decision by the co-op, even after the receiver has been appointed and given all the powers that Mr. Moore described. And I'm wondering whether is that your position, or do you dispute that the receiver can't now make the decision itself, given its authority, without regard to a vote by the co-op?
To be clear, the relevant point in time is 2016, and at that time, the receiver was not appointed. Now that the receiver is in place, I don't believe that the receivership order gives the receiver the right to increase the insider price. So my response would be that I don't think that is something that could be done.
Well, the receiver is presumably bound by the terms of the agreements. So in that sense, the receiver is somewhat bound. But the question is whether the receiver could say, well, look, we're doing a good faith estimate, or good faith, we're making good faith adjustments that were contemplated under the agreement. So instead of $149,000, it needs to be X. And we, the receiver, have the authority to do that without regard to a co-op association vote or approval of it, because we're the receiver. Do you contemplate that that's permitted or not?
Maybe, but that would be an entirely different future action. And before any action it would require issuing a new notice and triggering a new opportunity to purchase. So this is very hypothetical, and we have separately appealed a denial of the member's right to intervene in the action in which the receiver was appointed. So that's
just to be clear on something. So who set the prices at which the units were offered to appellants here? Were those prices set by the receiver, or were those prices set by the association?
Well, they were certainly not set by the receiver because the receiver was not in play. But whether it was set by the by the cooperative, we really don't know. We don't know who set those prices because there's absolutely nothing in the record of
I
who.
see.
I mean, the letter, sure. I mean, it says the Randolph Towers Cooperative hereby offers you the right this price. I mean, it's written by an attorney for the cooperative, but that's what the final notice letters look like. That's not sort of proof positive that this is the cooperative setting the price.
No, I don't think it is. I think if there were.
I mean, we don't know. You could say, well, maybe, some representative of the cooperative authorized the lawyer to write this letter, but they didn't go through the proper bylaw procedure of, a board vote. Like that could be one answer, but I'm surprised that you think that it's just news to me that there would be a dispute that the cooperative had originally set that price. That's sure what the letters, what the letters seem to say on their face, but I didn't appreciate that was a disputed point.
I don't think that we would concede that. And for example, the letters also say your membership has been terminated, and we don't concede that that was done correctly either.
Right, no, for sure. I mean, no, I mean, there's two different positions you might take. One might be, yeah, sure, this thing was written on behalf of the cooperative, but they didn't go through the appropriate channels to make this offer. They should have had a board vote and they failed to. That I get. If there is a separate, when Jonathan Schuman wrote on this letter that he was writing on behalf of the cooperative, he was lying and that was inaccurate and he was unauthorized to write that letter. That's just a different type of argument that I take it you're really not pushing the second type. That we're just in the first land. Maybe it was on behalf of cooperative, but not they were not through a proper method.
And perhaps
not in accordance with the bylaws. Okay, I'll just stop talking, Judge Howard.
No, I was gonna say, perhaps confirm for me. My understanding of your client's argument is it's that you just don't know, that there's no way to verify anything, that you've got an attorney letter, but you don't have not even a board vote, but you don't have board minutes about it. You don't have any reports, any analysis, nothing that went into the letter. You just have the letter itself. Is that your assertion below?
Right. There's no evidence to generate a material dispute of fact on this issue of the validity of the notice.
And let me ask the kind of stupid question that I presumed already, but discovery concluded at the point that this motion went in, correct?
Absolutely. Yes, Your Honor.
Before the offers that are at issue in this appeal, were there previous purchase offers made to these tenants, to these occupants?
Not that we know of in the record. And not that were relied on by either the cooperative or Longgate for the basis of an alleged termination. So Longgate or the cooperative could have said, look, we gave you this formal letter that has the same language as the 2016 letter, or we gave you, some other letter that has the magic words in it, but their entire case relies solely on the August 4th, 2016 letter.
Why was there such a long delay before these August 2016 letters went out?
We also don't have the answer to that in the record, and I personally don't know the reason for the long delay. I believe I was going to speak a little bit about the collateral estoppel issue. So here,
if I may just, if you are right on, I take it that your position is that if you are right that those offers, that the judge properly found those offers not compliant with the contractual obligations, then that's the end of the matter. You were entitled to summary judgment. You can't be evicted because the condition precedent to eviction has never occurred. And no other issue needs to be resolved. Is that right?
That's right.
Am I stating your position correctly?
That would be a sufficient basis for affirmance. We have additional arguments that also justify affirmance, but that in and of itself would be sufficient.
Okay, and you wanted to talk about collateral estoppel.
I did. The Sunube decision was on the same legal basis that we're discussing. It did take into consideration the bylaws and the occupancy agreement. It did speak to the requirement of the votes of the board in order to terminate membership. And the argument advanced by Mr. Moore that there is some consideration of fairness, that's not the case when collateral estoppel is raised defensively. When it's raised offensively, the case law does suggest that a consideration of fairness factors into the analysis, but this court has said that when raised defensively, collateral estoppel is applied with rigid finality. A claim that the first court got it wrong, that there is some error in the first decision, is not a sufficient basis to avoid application of collateral estoppel. And to be clear, we're raising this argument in the alternative. Either Longgate lacks standing, or if it has standing, if it's in privity with the cooperative because it's asserting all the rights coextensive with those of the cooperative, then it is precluded on really relitigating these issues that resulted in a final judgment and that was not disturbed.
Do we have enough information before us about the, I don't think I have the name correctly of the other of the lawsuit, the one that you wish us to give collateral estoppel effect to? Or is
I
this
think-
something that would need to go back down to the trial judge?
No, Your Honor, I think the reasoning of the opinion is so clear here, and there's such a one-to-one application. Both Judge Higashi explicitly referenced Judge Puiglugo's decision, and I believe quoted from it or approved the reasoning. And Judge Rigsby crafted his order in some ways almost verbatim, drawing on the language from Judge Puiglugo's decision. So those two judges were satisfied that the reasoning held up equally in these cases. I want to discuss a little bit the statute of limitations issue. I believe Mr. Moore conceded earlier that this was a breach of a contract, that this was a breach of an occupancy agreement here. And by the terms of the August 4th, 2016 notice, that notice expired September 16th, 2016, meaning by its own terms, the earliest the cooperative could have maintained a suit to successful conclusion would have been September 17th, 2016. The cooperative did in fact initiate a suit against Ms. Ochoa and Mr. Nunez, alleging that they had failed to purchase their unit according to the contributor participant agreement and the notice that they were issued, which is the same notice relied on here. And then the cooperative voluntarily dismissed that case after the Sunube decision was rendered. Therefore, the 3-year statute of limitations that would apply for a breach of contract action elapsed before Longgate initiated this suit against Ms. Ochoa and Mr. Nunez.
I have found myself wondering whether this is really a breach of contract action, as a question I asked Mr. Moore indicated. It struck me that the nature of the claim is not that there was a breach of the contract, but that the tenants simply did not wish to purchase. Okay, they don't have to. It's predicated, of course, on the validity of the purchase offer. That goes without saying. But the tenant, and I said tenants, the occupants didn't wish to purchase, so they are like holdover occupants instead of holdover tenants. They just don't have an occupancy agreement anymore, and that's not a breach of the occupancy agreement. That's just the termination of the occupancy agreement. And so my thinking was, there is no statute of limitations applicable, or the statute of limitations for breach of contract is not applicable to that. And I would have thought that when you have a tenant in sufferance, or an occupant in sufferance, the landlord can, on appropriate notice, seek their eviction at any time. Why is that not the right way to look at this?
This court has said that for purposes of statute of limitations, the court looks not to the way that the claim is pleaded, but to the substantive elements of the claim. And as we've discussed here, the substantive elements of the claim all sound in contract, right? Offer.
Do the
Counsel, what-
members have an obligation? Did the members have a contractual obligation to buy the unit if the price comported with the agreement? The occupancy agreement?
There was no obligation.
I had thought not. That's
Correct. There's no obligation to purchase. However, Longgate's position in this case is either they had to purchase or they had to leave. And so by not doing either, according to
The
Longate.
failure to leave isn't a breach of the contract, though. The failure to leave is you've got no other justification for being there. There's nothing that allows you to be in there absent this contract that is now terminated.
Yeah, it's not that the
Which is what-
contract was breached, it's that the contract functioned and now no longer exists per its own terms.
I think
Yeah, the nature
that-
of the claim is more like you're squatting. You know, you have no right to be your client, not you. Your clients have no right to be there. They had one under an occupancy agreement that has terminated.
that may be a plausible interpretation. And maybe that is exactly why Longate styled its claim as one for tenancy at sufferance. The court need not reach this particular issue in order to affirm. Judge Rigsby found it persuasive, and because, again, we've discussed all these terms like the occupancy agreement, what was required, I think that the more fair characterization of the claim that Longate has brought here is a breach of contract claim. I think there were just a couple other points of very minor clarification, but I know I've gone over time as well, so.
okay. Well, I appreciate that. Thank you. We'll hear from Mr. Moore. Mr. Moore will give you a couple of minutes in rebuttal.
Thank you. It does not appear that the court is too bothered by statute of limitations. We did cite case law showing tenant at sufferance. Basically, you can file that at any time in action. There is no statute of limitation under an older case from this actually not that old, 1990, from this jurisdiction. It says there is no statute of limitations. And here it's more about whether I characterize it as a breach of lease, it's really what the remedy is. Similar to, I don't believe there's a statute of limitations for a tenant holding over. The remedy is expulsion or eviction of a holdover tenant or a tenant at sufferance here, or a holdover occupant, I think is one of you termed. And that remedy is never going to expire for the landlord. It's not as if we're seeking damages that would, once you get behind all the damages that are more than 3 years old, you could not pursue under a tenancy situation. So quickly to Sinupe. I mean, this court said in Madiri that it applies non-mutual collateral estoppel with some caution because the potential where there was little incentive for the defendant to pursue the claims, the party here, and I know that's defensive collateral estoppel, but the receiver, although it may, as the court put, may or may not stand in the shoes, and I don't think it stands in the shoes of the cooperative entirely. It does not. It simply holds the purse strings. It would not be responsible. I think there's a case against somebody who's actually a tenant right now proceeding in the civil branch of the Superior Court. I think there are claims that tenant has going back to when the cooperative was in control. That is not something that the receiver is burdened with. The receiver is only burdened with the condition of the property since it took control of the property. The receiver should not be burdened with a decision in Sinupe because of the unfairness. The cooperative, possibly given its financial status, simply stopped fighting you can see that, and the issues were different in Sanoop between the parties. The case was different. The receiver really should not be burdened with something that took place 3 years before it was ever appointed and was not fully litigated, which is one of the factors.
Well, Mr. Moore, in all fairness, if the receiver shouldn't be burdened with something that happened 3 years ago, then why should the appellees be burdened with the letter that came out 3 years before and has an equally murky record in litigation behind it?
Because that is a part of the contracts they signed with the contributor participant agreement, the bylaws, and well, I don't know if they signed the bylaws, but they did sign the occupancy agreement and the contributor participant agreement. And they are burdened with that. And I think, as the court has pointed out, the cooperative and now the receiver has the power to change those prices and should be given the opportunity to show that either the price in Mr. Schumann's 2016 letter was justified, or the price that could be set now by the receiver.
Does anything stop the receiver from just issuing new offers of purchase to the occupants and going from there?
No, I don't believe so, because under the amended order signed by Judge Rigsby, I don't have the date of that order, but the court's familiar with it and has referred to it. The receiver does have the power to do so. And under the powers that the cooperative had under the bylaws and occupancy agreement, it could certainly justify an increased price.
But it didn't do that, so the receiver was relying instead on the offers made by the predecessor.
Correct, feeling that those prices were more than justified by the changed factors noted in the briefs that we submitted in both appeals that tried to explain the forbearance agreements and all the loans and interest that had been accruing for the last 15 years, and as to why the price had jumped substantially. I mean, there are a lot of people who want to get paid, not just the lender here, the tenants, the condominium association, and perhaps members who want something for their membership interest.
Mr. Moore, let me ask you too, just to clarify, you're referencing those forbearance agreements. I think it sounds like that has to do with the motion that we haven't ruled on yet. That's there where where you supplemented the record for your client, and it's opposed by appellee and not being part of the record below. Are those the forbearance agreements you're referencing?
Yes, I think our justification, they were provided in discovery, and that was to give the Court of Appeals, a better idea as to what circumstances have changed as to why it's not 2006 anymore. There are some more than hints, strong hints, and back in the documents that were created in 2006 that things might change. There are statements by Aaron O'Toole in his letters in 2009 that things are changing, but the forbearance agreements simply support the continued increased burden on the cooperative of these loans and why a higher purchase price is needed. We're not attempting to necessarily show that the facts were before the judges below, but to show that it is, I think, an incredible belief to think that the estimated purchase price in 2006 could still be enforceable. Wasn't in 2006, but could still be enforceable in 2019 or 2020.
Yeah, well, the issue is whether the substituted price is enforceable.
Yes, Your Honor. I agree with that, and I believe that if this is remanded back to the trial court, we could certainly produce evidence to show that as Judge Howard said, the 30% increased price was justifiable in 2016 based upon the debt encumbering the cooperative and what would be needed to pay everybody off. Remember, the cooperative also has to pay the tenant association. I believe there is a judgment of over $450,000 that I hope I didn't call it tenant association, that the condominium association has as a lien on the cooperative as well. So it's not just.
Is that part of the record below?
That's public. I think that occurred after summary judgment was granted, but is certainly information that is, no, I don't think it was part of the record because I don't think it had occurred at that time. I may be mistaken.
Okay. Well, I'd like to thank both counsel.
Thank you.
And the case is now submitted and you may log off.
Thank you, Your Honors.
This honorable court is now adjourned.